Press the Let's Go Live button. So let's wait for the stream to fire up all across the fruited plain of the internets. Before we go ahead and get started, we got to make sure the tubes are working, lest we be rambling off into oblivion. Don't want that to happen. But it looks like they are connected. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about those D.C. judges from the D.C. Circuit Court of Appeals and how they have rejected presidential immunity. We're going to go through this opinion. I expect it to be appealed. I expect the Supreme Court to accept the appeal and hopefully correct the record on this, because it's a pretty big issue. And of course, this is not a good ruling for the Trump team, but we already knew this was going to be happening, right? We expected this. In no reality did we think that the DC Circuit Court of Appeals was going to come out and find that this case is going to be dismissed. And so we're going to talk about it. We got the 57-page opinion that we'll go into and hit the highlights on what is inside. We're going to refresh our recollection on who these judges actually are, courtesy of Julie Kelly. Remember, we've talked about them before because there was an oral argument that took place out of their courtroom before they issued this ruling about a month ago. I think that was actually on January 9th. So just coming up on a month ago, there were oral arguments there. And remember, John Sauer was there arguing on behalf of Trump. And this stupid question came up about SEAL Team 6. And he handled it very nicely. But what we're going to find is in this 57-page opinion, they kind of beat around the bush on that issue a little bit, right? They kind of just gloss over the impeachment judgment clause and why in our constitutional order, we would have a mechanism to ensure that there are no political prosecutions that are happening. That is, of course, the impeachment process, which involves a trial and a conviction. And Donald Trump was acquitted by the Senate. And they coped themselves into a pretzel to try to make that fit. Well, some senators acquitted him for other reasons and all of it. So we're going to listen to him and see what is inside. Now, the big question, the big issue, yesterday on the show, we heard from Neil Katyal over on MSNBC's hit show called Inside Jen Psaki. And he was saying, man, I'm in freak out mode. Remember that? I'm freaking out, man. This is taking a long time, and we really need to get Trump convicted before the election, or else we're probably going to lose, and it's going to be a big problem. And so there is a lot of conversation now happening around timing. How quickly is this thing going to happen? Because the Court of Appeals did something a little bit, questionable, and they kind of changed the rules. They said, well, you got like 12 days, you got 7 days until Monday the 12th to file with SCOTUS. Otherwise, the case is getting handed back off down to Judge Chutkan, and then Judge Chutkan is going to, of course, try to get this trial back on track. And it's going to be just, free for all. And I'm kind of hoping we have a trial actually before the election. Let's do it. If they want to do it, let's do it. We'll go. So anyways, Cheney, this guy, Kyle Cheney on Politico, he gives us an analysis. I got Jonathan Turley, who gives us some, calculations. And there's, it's going to be close, man. So we don't know if there's going to be an election trial before the election or after. But there was some interesting things that were happening. And so we're just going to poke around. We're going to see what Shipwreck Crew had to say about this. Seemingly like they're fast tracking this thing. They're kind of breaking the rules, to get Trump. Go figure. But we also have some reaction. Speaker Johnson responded to this very briefly. And then Congress also, this guy came out and said, Trump had a right to contest the election. That's perfectly lawful. And then Trump responded about this over on Truth Social. And so we're going to get all into that and into all of that on the very first segment on the day. The big story, of course, that broke fresh, bright and early this morning. Then we're going to talk about the Supreme Court and Crazy Eyes Griswold, the Secretary of State from Colorado. She has been out and getting prepared. We've got oral arguments in the United States Supreme Court on an issue about whether Donald Trump can remain on the ballot because this woman and people like her want to throw him off in order to save democracy. Okay, so in other words, throw a candidate who's going to be the nominee of the party off the ballot to save the American constitutional order. So Crazy Eyes is out talking about this, posting on X that she's very excited about this, saying, she's got 10 minutes of oral arguments that she'll be available for, or her team will, her attorney or somebody who's actually intelligent will be there making those oral arguments. And then we'll hear from her. But Trump submitted his final reply. So this is the final word before the oral arguments take place on Thursday. And so we're going to go inside of it and see what they are saying, this is a democracy. We thought this was a constitutional republic, and throwing people off the ballots is new, new in our country. So Matt Gaetz also came out, and he is now introducing a resolution to officially say that Donald Trump did not commit an insurrection. And so we're going to talk about that. And there is, it's an interesting idea. It makes me a little bit nervous, because what happens if you get guys like Ken Buck are actually he did. And maybe they vote to find that he did actually commit an insurrection. So we've got some stuff in the House that's taking place. Elise Stefanik was there by Matt Gaetz' side, and they were introducing this. And we'll see what they say as the House starts to create a response. And so, my friends, that is what is queued up. We are grateful that you are here and with us, and looking forward to digging into all of these stories with you. This morning, we had a beautiful stream on our members only stream. We talk about additional stuff that we can't get to here with our membos, YouTube membos, locals membos. We do streams in the morning. We do Saturday streams, and we like to get our days started off right, getting our bearings straight on what's happening in Congress. This morning, we talked about the fresh breaking news, like the Trump opinion that just dropped this morning. We talked a little bit about that. We broke down the border stuff, and we've been really, covering the elections and all of the other stuff that we can't get to here. So come check us out, watchingthewatchers.locals.com. And we do after parties. So as soon as we're done here, we're going to hang out for our members only over on Locals. If you want to grab any of the PDFs that we're about to go through here on the day, you can check out the link, robertgovea.com. We have our newsletter is there. Our shop is there. And it's a great way to get the PDFs. They're all in the reports section. We try to chronicle this stuff so that you can share it with other people who need to know. And tomorrow, we're very excited at our Watcher Lodge. So watcherlodge.com. This is our newest project. We have our very first public event, which is going to be building your survival squad. And I'm excited about this event. I think it's going to be a lot of fun. So it's tomorrow, 10 a.m. Might go longer than a 10 a.m. my time. So that's noon Eastern time. So you can register for free. Go to watcherlodge.com. And I've got some cool stuff that I'm going to be sharing with you guys. So first of all, these are my slides. So I've got the slides that are queued up. We're going to talk about the 4 roles that are important in a survival squad, whether it's you or your family, or whether you and your friends or whatever. We're going to talk about that. Then we're also going to put together our emergency master plan, our EMP. So I put this document together with my notes, and it's just your master plan in case there's an emergency. What are you going to do, right? Do you have written instructions that are printed out, hard copies? Do you have your out-of-town contacts in there? Do you have your critical household information? Do you have emergency-specific details? Do you know how to evacuate? Do you know how to shelter in place? All the checklists, all the things. It's our emergency master plan, our EMP. And so that's what we're talking about tomorrow. And I'm super excited about it. I can't wait to get into some of this workshop masterclass stuff. I think it's going to be fun. We're going to have fun. So if you want to sign up, it's all free. Watcherlodge.com. Links are down in the description below. And we can't wait to see you there tomorrow. And you don't need to pay to become a member, okay? It's going to be free, and we're going to keep it live for 48 hours. So it's not going to be there forever, but come join us, and then it's going into the archives. All right. And so check that out, watcherlodge.com. Okay. Now, my friends, now it is time to get in to the meat and potatoes on the day and see what is inside. DC judges reject presidential immunity for Donald Trump, and nobody's surprised about this. We all knew this was coming. Why? Because we heard during oral arguments some of the bizarre questions from the judges who were saying things like, can Trump murder everybody in Congress? I'm going, okay, relax, ladies. So these were the judges who were actually behind this ruling, and we're going to see what they wrote in their 57-page opinion that came out of the DC Circuit Court of Appeals. We're going to talk about timing, about when this trial is going to happen, if it is going to happen before the election, as Jack Smith and the Democrats really want. We know they're freaking out to get this back on track. We're going to get reaction from Johnson and others, including Trump himself. But before we dive into the actual opinion from the judges, our friend Julie Kelly over on X at Julie_Kelly2 on the X platform, she says, just so you're aware of who we're talking about, a lot of these judges like to hide behind their robes, their gavels, and their closed down courtrooms. But here's the people that we're talking about. The first 3 judges were appointed by Obama and Biden. Okay, so Judge Chutkan, you know her. This is the other judge who's on the bench. And this is Judge Pan, I believe, also on the bench, all appointed by Obama. And so, you just kind of have, that's what they look like. Now, the other judge has been on the court for 34 years, this woman, and she was appointed by Bush. And she's actually older than all of the other Supreme Court judges who are there. And in the Supreme Court, all right, so like been around for a long time. So they took about a month to draft this opinion. They listened to oral arguments, and they came up with their conclusion that Trump is not immune. And so we're going to go through that. We're going to jump back out and refresh our recollection about what the actual question was, because in this opinion, there's going to be a lot of arguing around the point, okay, getting around, like they're gonna make a lot of arguments. It's all gonna sound good, but that's not what we're actually talking about here. And we've seen a lot of this with the Trump stuff, and it's pretty bad legal crafting. But I think honestly, if I can just for a second think about this, why are they doing all of this? In other words, they're breaking standards. They're setting bad precedent. All of this is for a reason, right? It's to stop Trump. And I think there's this unspoken rule that's happening throughout all this litigation, especially these appeals. It's that this is not going to happen again, okay? We're not going to have another president come through our courtroom again. We're not going to lose control again. So we're going to be willing to break and bend and maneuver all of these rules, all of this precedent, because it's only for Trump. As we say here often, it's break glass in case of emergency, but we're not going to have another emergency because we're never going to lose control of the presidency again, okay? So they'll shatter this, and they'll say there's not going to be that many consequences to the executive branch because we're never going to be here again. But we're willing to do whatever it takes now, right now. Now, nobody's going to say that openly. Nobody's going to say that in public. But that's, these are supposedly accomplished judges, right? And supposedly they're, credentialed and they deserve to be where they are. But that's the only explanation for this, is they're breaking the rules because of Trump. All right, let's get into the opinion. Without any further ado, here's what it says. United States Court of Appeals, District of Columbia, case, of course, as we know, the U.S. government, Joe Biden versus Donald Trump, using the DOJ as a political tool against his enemy via Jack Smith. It's a 57-pager. We're going to hit the highlights. We remember John Sauer, and we have a clip from him. He was the person who did the oral arguments back when they were before the court. Now, quick note on this. Those judges, those 3 judges, right? It's not the full Court of Appeals. Trump will have an opportunity to resubmit this to the full panel. It's called en banc. He could say, yeah, we're going to go to them and we're going to see if we get a different outcome. Probably not. Maybe he'll do that. Maybe he won't do that. Maybe he'll just take it right up to the Supreme Court. We don't know. But the point is, these judges are supposed to stand for something, right? I mean, they're here, they're saving American democracy and all of this stuff, and they're concocting this opinion. But they don't have the courage to even sign their names to it. You'll notice that. Here's the opinion for the court filed per curiam. It's the opinion of the court. Okay, it's just the opinion of the court. Nobody signed it. You normally see something like this. Now, it's before these judges, Henderson, Childs, and Pan. Normally, you'll see Henderson, with whom Childs and Judge Pan join, right? Or this person joins and this person dissents, with whom this person joins, right? But they didn't even sign their names to this, right? Not even sign, it's just pure curiam. It's just the opinion of the court. Well, what's up with that? If you're going to be, enacting historic precedent, don't you want your name behind it? Or the answer is no, right? Because they know this is not good law. They know that they are breaking glass in case of emergency. They just have to write this just to stop Trump, okay? But if this was reconcocted, if this was brought against Joe Biden or brought against Barack Obama for executing American citizens, or Biden for causing an invasion at the southern border or whatever, okay, there would be a strong defense of the presidential actions. But they are, it's kind of like when you stab somebody in the back, you don't want anyone to know about it. So just pure curiam. No, this is a good opinion. It's really good law, but we're just not going to sign it. So nobody knows who actually wrote it, and it's not anchored in on my record in the history books. Okay. So they write, per curiam, bunch of weenies, says Donald Trump was elected the 45th president. He was sworn into office. We know that. And his term expired on noon. Now, at that moment, they write, President Trump became former President Trump. Wow. Now, although the sequence is set by the Constitution, it did not proceed peacefully. From Election Day 2020 forward, the government alleges that Trump denied that he had lost his bid for a second term, and he challenged the electoral results. There was a rally held on January 6th. The rally was headlined by Trump, and there was a breach at the Capitol. And the breach, this so-called insurrection, they even admit in this circuit court, it delayed the congressional proceedings for several hours. Wow. Wow. Several hours. And it was not until the early morning of January 7th, which was like midnight, okay, big deal, that the results were certified and Joe Biden was sworn in as the president, soon to be president, confirmed. Thanks for that. Now, since then, hundreds of people who breached the Capitol have been prosecuted and imprisoned by their political enemies. And Trump was charged with a 4-count indictment as a result of his actions. Now, former Trump moved to dismiss the indictment, and so we're going to pay close attention to this. What are we talking about in this filing? It was a motion to dismiss, and the district court Judge Chutkan denied that. Today, we affirm Chutkan's decision. Now, for the purpose of this criminal case, former President Trump has become citizen Trump. Now, this is an interesting statement here, with all of the defenses of any other criminal defendant. But any executive immunity that may have protected him while he served as president no longer protects him against this prosecution, which is a wild thing to even, to say that, because it's like the actions that they're charging him with crimes over, he was the president at that time. Okay, he didn't commit a new crime. He didn't leave office in January 21st, and then go commit a new crime. In this case, the allegations are about January 6th when he actually was the president, and he actually did have control of the government, and he did have a duty and an obligation to make sure our elections aren't rigged. So what they're acknowledging is apparently they're stripping him of that prior. We're just saying we're taking him out. He's no longer the president, so we don't have to really think about that. Now, I want to also pay close attention to this, because what are we talking about? Yes, this is Trump's motion to dismiss, certainly. And so what standards are we applying to this? Like, what does Trump have to show the dismissal? And the basis for the dismissal, which is going to add another layer to this, is immunity. Okay, so it's not motion to dismiss because of a corrupt prosecutor, like maybe we see in RICO case in Georgia, or a motion to dismiss because there's no evidence, right? They lost the blood results or something. It's a motion to dismiss because the president is immune. It's not necessarily a problem with their case, but it's that the president has immunity. And that's kind of a separate thing than a regular, just generic motion to dismiss. So how are they treating this? Are they treating this as a motion to dismiss, affirming that we've got immunity, and then applying a new immunity standard? Or are we applying a motion to dismiss standard? How are we measuring? What's the measuring stick against which we are proceeding? So let's see what the court tells us. Here's the background. They say Trump did not concede 2020. His supporters made numerous attempts to challenge the results. Many attempts were allegedly criminal. Allegedly. Yeah, from Fannie. Now, a DA, a District of Columbia federal grand jury, returned an indictment. We know the 4 counts. And of course, as you'll know, let's just confirm this, not a single insurrection charge amongst them. Conspiracy to defraud the United States by overturning the election results. So a conspiracy to defraud. Another conspiracy to obstruct an official proceeding. Okay. Obstruction of the official electoral vote count, and a conspiracy against rights, Section 241, to have their votes counted. All of these were just conspiracy charges, right? And the things that they're alleging, the conduct, like what is the conspiracy to have their vote, saying you tried to take away people's votes. Why was that? It was by him enforcing the rules, saying, were those votes counted? Did you have the signatures? In other words, leading the investigation. So they're saying that all of that conduct is criminal. Now, we emphasize that whether the indictment's allegations are supported by evidence sufficient to sustain the convictions must be determined at a later stage of the production. But here is what as I backed up, and we're talking about these standards, right? The motion to dismiss the indictment. So what they're doing is they're going to say, At this stage of the prosecution, and we kind of want more there. What stage? At the motion to dismiss stage with an immunity provision, he says, we assume that the allegations set forth in the indictment are true. We're just going to presume that whatever Jack Smith said is true. And you might say, well, that sounds problematic, and it could be problematic because, again, we don't really know what the standard is. Like, what's the measuring stick? We don't know. But think about it this way. Like, if someone's going to file a motion to dismiss against you, you want the benefit of saying, well, if they're going to move against me, they need to show that even if everything that I said is true, they would still win. Then you could dismiss my case. So in other words, we hold the non-moving party in a light most favorable to the non-moving party. So since Trump is moving to dismiss it, they're going to say, okay, well, let's say that everything that Trump says, everything in the indictment is true. If Trump still merits a dismissal in the aftermath of that benefit of the doubt, then we'll dismiss it. And immunity would actually do that, right? You could say everything Jack Smith said is true. That's fine. Trump has immunity. It's just like self-defense. It's like, yeah, I punched the dude in the face. Yeah, I broke his nose. Yeah, there's blood all over the place. I'm, not happy that he's unhappy with that. That's true. But I was privileged, right? I'm immune from charges because I was acting in self-defense. Same concept. So the indictment here alleges that Trump understood, which they're going to have a hard time proving that. I've never got that sense, that he had lost the election, but nevertheless that the results were legitimate, and he knew that the results were legitimate, but nevertheless he was determined to remain in power. He then conspired with others to cast doubt on the election outcome to contrive himself to be the winner. Now, the indictment charges that he and his co-conspirators used 5 primary means. 1, false claims of election fraud. So they said, we have an opinion that the election was rigged, and they said, you can't have that opinion. And they said that there were statements they went through. 10,000 dead voters voted in Georgia, 205,000 more votes in Pennsylvania, 30,000 non-citizens in Arizona, right? So they were, I guess, spreading misinformation about this. Second, then Trump and his co-conspirators, then they organized fraudulent slates of electors, which we've seen in prior elections, like I think 1960 back in Hawaii, when they had alternate electors. So then they caused the fraudulent electors to transmit their certificates to VP Pence, which again, you would do if you were anchoring in your party's position, right? You're saying, hey, we're going to contest this. This is our slate. It's an alternate slate from the party. We're challenging this. Third, then Trump and his co-conspirators, then they contacted DOJ officials. They said, hey, can you investigate this stuff? And they said that there were false claims that the DOJ had identified concerns. And then fourth, that they put pressure on Mike Pence to encourage him to undo it. And then fifth, of course, was the icing of the cake, the J6 rally. So then Trump, he made efforts to overturn the Constitution, and there was an impeachment that took place. Now, 9 days before Biden's inauguration, the House adopted an impeachment resolution under Nancy Pelosi called incitement of insurrection, the same allegations that are happening here in this case. Now, the impeachment resolution, it asserted that Trump repeatedly issued false statements about the election, and they tried to impeach him on that. But he was acquitted. Now, by the time the United States conducted the trial, he had become former President Trump. Now, at the close of trial, 57 senators voted to acquit him. And because 2/3 of the Senate did not vote for conviction, he was acquitted. But they're going to say that doesn't really count, right? They're going to say, well, some of those senators didn't vote. They voted to acquit him on other reasons. And so they all didn't have the same reason. And so we're not really going to count that. And the impeachment judgment clause doesn't apply. On November 19th, then U.S. Attorney General appointed John Smith as special counsel to investigate all this. And of course, we got an indictment after August 1st, 2023. So Trump is here. Now he's saying a bunch of things. 1, presidential immunity, constitutional provisions like the impeachment judgment clause and double jeopardy prevent him from being charged again. He's already tried on this in the Senate. He was already acquitted. We just gave the checkbox right here. Boom. He was acquitted on that. So how are they trying him again? On December 1st, the district court, Shutkin, rejected all of his claims, saying that there's no way that a president could be exempt. Trump filed a number of appeals, and here we are today. Now, the court is going to give us some jurisdictional stuff, right? And we'll fast forward through a lot of this. Usually this is pretty technical. They're talking about district court orders that are, basically we've got the authority to hear this case. And we'll fast forward through this. We exercise jurisdiction for a couple of reasons. And we can, we can hear this case. Lot of case law, right? They're going through Midland and other things. American oversight hinges on this. Supreme Court has distinguished that. The court ultimately here, there's not a good reason to read this way, blah, blah, blah. And so procedural rules about what they can do. So let's get to some more analysis about their background here. Now, former President Trump and his two arguments, they can be analogized to constitutional immunities, which these other cases require. Now, his separation of powers argument does not explicitly draw on speech or the debate clause like they did in those other cases, but the immunity for official acts that Trump asserts is closely akin, so they're trying to analogize this to another case, closely akin to a speech or debate clause. So this is really the type of immunity that Trump is trying to claim. And they've got this other case law where it kind of matches that. Likewise, Trump argues that the impeachment judgment clause incorporates a double jeopardy principle, right? How can you be tried twice for the same offense? And Trump was acquitted in the Senate. Now, we found a similar line of reasoning that's convincing in this case. If a treaty provision mirrors the double jeopardy clause, so does a constitutional clause that attaches jeopardy to the impeachment acquittal. Now, both of former President Trump's arguments are the least analogous, are at least analogous enough to the speech or debate clause and double jeopardy to fit within our precedent. Accordingly, we conclude, okay, this is the jurisdiction section, that we have jurisdiction to reach the merits on the appeal. Okay. So they can hear the case, fine. Now, for all immunity doctrines, the burden is on the official claiming the immunity to demonstrate the entitlement, right? Now we're talking standards. Here, former Trump claims absolute immunity from criminal prosecution for all official acts undertaken as president, a category he contends includes all of the conduct alleged in the indictment. So that is a little bit overbroad, isn't it? I think it is. So that's kind of not what he's saying exactly. So all official acts, well, I guess that is true. Now, the point here, they're leaving out a little parentheses, right? They're leaving out the point where the Congress has a check on this. Okay, so they like to use this talking point that Trump claims he can do whatever he wants. He has absolute immunity. Well, sort of, but Congress can eliminate that, okay? Like absolute immunity subject to Congress. So it's not really absolute. I mean, it's pretty close, but if Congress impeaches you and convicts you, then that is shattered, okay? So it's not really absolute immunity. Absolute to me means nobody can take it away from you. There is a mechanism to take that away from you. Very easy. All Congress has to do is impeach you and convict you. And by the way, that is a normal process in law. Happens all the time, that you have safety proceedings to make sure that there is actually teeth there before you move something forward. For example, before you can be indicted with a crime, they got to show probable cause. We know this, right? Before you as a regular citizen can be charged, a cop has to think there's cause there and write a direct complaint against you and arrest you. Or a prosecutor needs to indict you, present the case to a grand jury, and show that there is cause in order to take it to the next step. So the same thing applies to the president. And this is a political safety valve. It's a safeguard. The president needs to be impeached and convicted. And we can, by going through that process, we know it's not political because there's a 2/3 majority. Even the president's own party, his own supporters are saying, okay, this dude's a criminal. So it's not absolute immunity. So this is, I think, overbroad. They just make that the argument. And that's not the argument. It's much narrower than that because we heard that even from D. John Sauer. This is the attorney on Donald Trump's team who is arguing this very point. Question from the judge, Judge Pan. Can he execute his political opponents? Here is what Sauer said in response to this.
But your position is that he can't be prosecuted for that unless he's impeached.
Yeah, that was, as long as it's an official act. I mean, certain cases, purely private conduct under Clinton against Jones, he'd be subject to prosecution for that as long as he's not in office. But as long as it's official act.
Could a president order SEAL Team 6 to assassinate a political rival? That's an official act in order to SEAL Team 6?
He would have to be and would speedily be, impeached and convicted before the criminal prosecution.
What if he weren't? There would be no criminal prosecution, no criminal liability for that?
Chief Justice's opinion in Marbury against Madison and our constitutional tradition and the plain language of the impeachment judgment clause all clearly presuppose that what the founders were concerned about was not.
I asked you a yes or no question. Could a president who ordered SEAL Team 6 to assassinate a political rival who was not impeached, would he be subject to criminal prosecution?
If he were impeached and convicted first. And
so your answer is
yes.
No.
My answer is qualified yes. There's a political process that would have to occur under the structure of our Constitution, which would require impeachment and conviction by the Senate. In these exceptional cases, as the OLC memo itself points out from the Department of Justice, you'd expect a speedy impeachment and conviction. But what the founders are much more worried about than using criminal prosecution to discipline presidents was what James Madison calls in Federalist number 47, the newfangled and artificial treasons. They were much more concerned about the abuse of the criminal process for political purposes to disable the presidency from factions and political opponents. And of course, that's exactly what we see in this case.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted? And your answer, your yes or no answer is no.
I said qualified yes if he's impeached and convicted first. We may be saying the same thing.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate a
She just changed the question.
Sale of military secrets strikes me as something that might not be held to be an official act. The sale of pardons is something that's come up historically and was not.
She just changed her question.
Says that.
Okay, so she just changed her question because she didn't like his answer. So then she threw in some other stuff. So she was trying to get an answer that she wanted. She didn't like his answer. She wanted him to say no. He didn't say no, but they respond as though he said no. They claim absolute immunity. He didn't say that. He said immunity subject to impeachment. But here's where they're going to continue to just argue for points that no one's making. So they say the question of whether former President Trump enjoys absolute immunity from federal criminal liability is one of first impression. That's not his argument at all, okay? It's a qualified immunity, okay? It's not absolute. Noting that, meaning if he gets impeached, it goes away. Noting that the unresolved question of whether or when a president might be immune from criminal prosecution. Says SCOTUS has consistently held that even a sitting president is not immune from responding to criminal subpoenas. And in the civil context, the SCOTUS has said that a former president is absolutely immune from civil liability for official acts if those are within the outer perimeter of his official responsibility. Okay, so that's civil stuff. So the president has absolute immunity from civil liability for his official acts, which is even broader than this because, arguably the impeachment judgment clause doesn't apply to that. Both sitting and former presidents remain civilly liable for private conduct, okay? And when considering the issue of presidential immunity, SCOTUS has been careful to note that its holdings on civil liability do not carry over to criminal prosecutions. Now, former President Trump, he claimed immunity would have us extend the framework for civil immunity to criminal cases and decide for the first time that a president is categorically immune from criminal prosecution for any act conceivably within the outer perimeter of his executive responsibility, which is true, but he's still subject to, that he could be charged, right, with impeachment. Like they just leave that out. It irks me. He advances 3 grounds for establishing this expansive immunity. Now, here is where they finally get to it. Article 3 courts lack the power to review his official acts under the separation of powers document because they're substituting their judgment for the president's judgment. They're saying, well, you can't do that or you can do that, but that's not their judgment. Otherwise, the courts become the president. If the courts can dictate to a president what he's allowed or to do or not do, then the court is the president, right, in many ways, especially for issues that are their official acts. So they say, number two, functional policy considerations rooted in the separation of powers require immunity to avoid intruding on executive branch functions. And then finally, that the impeachment judgment clause does not allow the criminal prosecution in the absence of Congress impeaching him and convicting him, which was a main point of their argument that they forgot in all of these other paragraphs. Thanks for finally acknowledging it. Now, our analysis is guided by the Constitution. Yeah, right. Relying on these sources, we reject all the bases for Trump's immunity. Now, they're going to give us some background on this. All right, separation of powers, saying the Constitution is important and the president occupies a unique position. Tell that to Judge Chutkan. Now, under the separation of powers, the president has executive power to take care that the laws be executed, which includes making sure our elections are not rigged. It's settled law, separation of powers in here. They say, nevertheless, look, Trump argues that the constitutional structure and the separation of powers means that neither a federal nor a state prosecutor nor a state or federal court may sit in judgment over a president's official acts because they're the president's acts alone. They can, but the mechanism in place to protect the presidency against those things has to be overcome. He relies on Marbury, but they say, sorry, Trump misreads Marbury. If you properly understood Marbury, they say the separation of powers doctrine, it may immunize lawful discretionary acts, but it does not bar the federal criminal prosecution of a former president for every official act, which again, they're not making that point. They didn't say that about Marbury. Marbury distinguished between two kinds of official acts, discretionary and ministerial. Chief Justice recognized a lot of this, a Marbury case law here. And then in Mississippi, there was some more law. Then the Supreme Court exercised some stuff over steel mills. Now, objections were made in the history of Marbury, and the Supreme Court has repeatedly affirmed that the judiciary has the power to direct appropriate process to the president. But the president does not enjoy absolute immunity from criminal subpoenas. We have that case that supported that one. And so the separation of powers doctrine, and summarizing all of this, as expounded and its progeny from Marbury that they just educated us about, it necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts, because the fact of the prosecution means that the former president has allegedly acted in defiance of Congress's laws. Now, although certain discretionary actions may be insulated from judicial review, they say if the allegation is that the president violated Congress's laws, then I guess that pulls him out. That's all you need. Here we finally get some application to the actual case. Here, former President Trump's actions allegedly violated generally applicable criminal laws, meaning those acts were not within the scope of his lawful discretion. And so, therefore, Marbury and its progeny provide him no structural immunity from the charges in the indictment. Crazy. This is crazy. So this means that any prosecutor can just shatter and just change the category of these things just by filing criminal charges. And you don't even have to, so there goes the presumption of innocence, in other words. If a prosecutor just says, allegedly, you acted in defiance of congressional laws, then that gives everybody power over the president because they said you violated the laws. And so therefore, you must be not in coordination with Congress. This is crazy. Trump's actions allegedly violated this, so he just gets, there you go, it's just outside because a prosecutor filed it. That's their conclusion. Now, our conclusion that the separation of powers doctrine does not immunize former presidents is reinforced by analogous immunity doctrines. Legislators and judges are absolutely immune from civil suits for any official conduct, and legislators have explicit constitutional immunity for speech and debate. But they can be criminally prosecuted under generally applicable laws for their official acts consistent with the separation of powers doctrine. But they are not the president. Oh my gosh. Legislators have explicit constitutional immunity, but outside of constitutionally protected legislative conduct, They also perform a wide, okay, so a bunch of case law again. Anytime you see me fast forwarding with all of these italicized cases, they're just explaining cases, right? It's a lot of filler. Just think of it as filler. We have a basis for doing this, and here's the case law to settle it. Here's most recent case law on judicial immunity, which again is not really, they're analogizing. So let's see how they apply it to Trump. All of this is case law. We therefore conclude, there's not much application here, right? We're seeing just a lot of copy and pasting here. So just as a backdrop, okay, anytime we analyze these documents, just so you're aware of what I'm looking for, in general practice, okay, the way opinions are organized are in the IRAC format. We talk about this a lot here, IRAC. You have an issue, you have the rules, you have the application, and then you have the conclusion. They teach you this first year law school. And it's a good way to organize your thoughts. It's a good way to organize your writing. So the issue, is Trump immune? Here are the rules, bunch of rules. The rules are as follows. We explain the rules, and you might even, some people call it IREAC. You put an E in here, IREAC, right? An explanation of the rules for better legal writing, a little sub-E there. But then you apply it. Then it's your analysis. You apply the rules to the case. And as we've seen here, okay, I've been fast forwarding through most of this because it's a lot of rules, lots of rules, but we're not really applying it a whole lot as we've been seeing. So then we get to some of this. Now, we therefore conclude that Article 3 courts may hear charges in the indictment under the separation of powers doctrine, as explained in Marbury and other cases. Now, this indictment charges that former President Trump he violated criminal laws of general applicability. Now, acting against laws that were enacted by Congress, he exercised power that it was at his lowest ebb. And so therefore, former President Trump lacked any lawful discretionary authority to defy federal criminal law, and he's answerable in court for his conduct. And I'm pretty sure that was the analysis for this section here. The analysis and the conclusion. All right, I mean, the rest of this is just explaining the rules. All right, so we're going to jump into the next section and see if it follows that same skimpy pattern. But here, now let's talk about functional policy considerations. Now, even though it is proper under Marbury for an Article 3 court to hear criminal charges brought against a former president, we still have to consider public policy, including our constitutional heritage and structure. Now, we note at the outset that our analysis, this is these people, okay? So here we're going to get some analysis, and this is a public policy position, functional public policy considerations, which we're not really concerned about as much as we are about the Constitution and about the logic of the constitutional order that we're trying to maintain here. But this is what I was explaining at the outset of this entire segment, is that they are trying to create a little escape hatch, right? This is their little, only in this case. That's why these weenies didn't even sign their opinion with their names on it. We're only going to bend the rules and break glass in case of emergency for this one case. We note at the outset that our analysis is specific to the case before us. And so we're going to stab every, American constitutional law in the back because of Trump. But we're not going to do it again, right? The next time this comes before us, they're going to have to do a different analysis for Joe Biden or for Barack Obama or for whoever the next president happens to be that is, charged with a crime. So they'll just shift themselves. We note our analysis is specific to this case before us. Well, thanks, because you put that at the top of the document. Okay, that's the title. That's the case we're here on. Thanks. In which a former president has been indicted on federal criminal charges for a conspiracy to overturn the election. Now, we consider the policy concerns for two reasons. First, possible intrusions on the authority and the functions of the executive branch and the countervailing interests if we allow presidents to be prosecuted. And we conclude that the interest in criminal accountability held by both the public and the executive branch, it outweighs the potential risks of chilling presidential action and permitting vexatious litigation. So those three women judges, they had a little balancing test, okay? And so they just put this little fulcrum right there in the middle. And on one side of this seesaw, they put immunity. If we grant immunity to Trump, that's going to protect the president right over here. But the public concerns are over here. And they just weighed these two things out. And they said, since we're the DC judges, we think this side is more favorable. And we just picked that side, right? And judges do this a lot. We just decided, well, this is what we think. It outweighs the potential risks of chilling presidential action, right? Because all of the other presidents are going to play ball. Presidents aren't going to, do things like Trump. And so there's no harm in us doing what we're doing because there's not going to be any consequences because all of the other presidents will not be Trump. Now, second, we examine the additional interest raised by the nature of the charges. The executive branch's interest in upholding presidential elections. And they say these interests compel the conclusion that Trump is not immune. Now, we do not address any policy considerations implicated in the prosecution of a sitting president or in the state prosecution of a sitting president, sitting or former. So again, they're taking this out of, they're not commenting on Fannie's case. Basically, they're only commenting on this case, not any other case from Trump. So here, they say former President Trump, he argues that criminal liability for former presidents, that it risks chilling presidential action while he's in office. And it opens the floodgates to meritless and harassing prosecution. They say, but these risks do not overcome the public interest in fair and accurate judicial proceedings, which is at the height in the criminal setting. And they just cite some case law for that. They say Trump asserts that the prospect of post-presidency criminal liability would inhibit them from being able to do their job. But rather, and they give us, again, a bunch of case law, right? The court reinforced this point and all these other cases in Nixon and so on, saying here, if applied to Trump, we cannot presume that a president will be unduly cowed by the prospect of criminal liability, like they're going to do their job. And the fact that you've got 4 indictments all in 1 year from 4 political hacks is not going to deviate another president, right? This is not going to chill their speech. And also, past presidents have also already understood themselves to be subject to impeachment and to criminal liability. And so other presidents have already acted with this without needing this immunity. Even Trump concedes that criminal prosecution of a former president is expressly authorized after impeachment and conviction, which, okay. So they're saying Trump even admits that he can't. This is so wild. So there's in the same document, these judges are saying even President Trump concedes that the criminal prosecution of a former president is expressly authorized after impeachment and conviction. Okay. So they get his argument. They understand what his argument is. They're not stupid. He made it at the oral arguments. We just listened to it. But in the same stinking document, as we just scrolled up, I'm not going to scroll up and find it here, but their argument, as we pointed out, was about absolute immunity. But they admit here, Trump concedes it's not absolute, right? All you got to do is be impeached and convicted. So we presume that every president is aware of the impeachment judgment clause, and they know that they're liable. And so what does he need additional immunity for? And historical precedent also suggests that former presidents, including President Trump, have not believed themselves to be wholly immune from criminal liability. Nobody has made that argument. Weird judges. Weird. Okay, like it's like the next paragraph. Additionally, recent historical evidence suggests that former presidents, even Trump, they have not even believed themselves to be wholly immune. Oh, that's true. No one's making that argument. But they're using that to make their point that he's not wholly immune. He's not absolutely immune. They just conceded that, and you admitted they conceded that right here. There's only a safety valve that you got to jump through. It's not complicated. They're talking about Bill Clinton's pardons. They say, in light of the express mention of indictment in the impeachment judgment clause and recent historical evidence of other presidents acting on apparent understanding that they could be prosecuted, the risk of criminal liability chilling presidential action appears to be low. So instead of it, they are, they're again twisting themselves to make their point. They're like, well, Trump already knows that he could be prosecuted. Okay, but you just said in your last argument that he's making the argument he cannot be prosecuted. So which is it? Instead of inhibiting the president's lawful discretionary action, the prospect of criminal liability might serve as a deterrent. Now, former Trump next urges that a lack of criminal immunity will subject them to politically motivated prosecutions. But we don't find that's accurate at all. A lot of case law. Here, now President Trump, so this is a good example of an IRAC. Okay, so next, right? So next. So when you're reading case law, you're looking for these signposts. Okay, next. So we're going to have a new IRAC right here. What's the issue? Here's the issue. The issue is that a lack of criminal immunity will subject future presidents to politically motivated prosecutions, right? So that's the issue. What's the rule? In the civil context, here are the rules. Supreme Court said, found, blah, blah, blah. Citation, quote, citation, quote, citation, quote, citation, quote. All of that is the rules, right? So when I was saying these people are just copy and paste, like most of this opinion is just copy paste rules. This is all the rules section. So you have just the one issue, you have the rules, and rules, they're fine. You can find rules for anything, just to be clear about this. You find whatever you want, just cobble them together. These are just little quotes. Courts presume that they ... properly discharge their official duties. So you have like, appellate legal briefers who are like excellent at this. They're just like pulling out cards one after another and just assembling. It's like amazing. But it doesn't really mean much, right? Now, then they jump into their analysis and they say, okay, as former president, Trump acknowledges this is the first time since the founding that a former president has been federally indicted. Now, weighing these factors, actually, that's still a fact. That's not even analysis. Weighing these factors, we conclude that the risk that former presidents will be unduly harassed by meritless federal criminal prosecutions, it appears to be slight. That's the conclusion. So I'm pretty sure we just got, yeah, that's our analysis section there. So there's really not much analysis happening, okay? They're just saying, well, all of this here. Additionally, former President Trump's predictive judgment, there's a little bit of application there. All right. So they're just jumping to conclusions, right? And they're arguing around the point, even in their own document. So on the other side of the scale, we must also consider the constitutional weight of the interest to be served. So it's another mini IRAC. These are IRACs stacked within each other. There's also a profound Article 2 interest in the enforcement of criminal laws. All right. We've got to make sure that no one's above the law, right? We heard that phrase. The federal prosecution of a former president fits the case to vindicate public interests, and the risks of chilling presidential action or permitting meritless, harassing prosecutions are unlikely, unsupported by history, and too remote. And so we therefore conclude that the functional policy considerations rooted in the structure of our government do not immunize former presidents from federal criminal prosecution. Next section. Indictments. The indictment alleges that assertedly official actions that are at issue here were undertaken by Trump. And they say it was done to make him unlawfully stay in power. Now, the alleged conduct violated constitutionally established designs. The 20th Amendment reinforces the presidential term. It's 4 years. The president has a duty to take care. And this duty encompasses a lot, right? The president has a duty to faithfully enforce the laws. This duty encompasses, they say, following the legal procedures for determining election results and ensuring that executive power vests in a new president. So they say that's the president's duty, and you have to do it the way that we do it. Now, to the extent that President Trump maintains that 2020 they say Trump can't say that that's all he was doing, right? There's this take care clause. The president has a duty to take care of their responsibilities. They got to do their job. And they have the power to do that, right? To make that happen. So he's relying on that to say, I had an obligation to go make sure the election was not rigged. They say Trump cannot rely on that. His conduct conflicts with the constitutional mandate to enforce the laws governing the process of electing the new president. So again, this is the court substituting their judgment, right? They're saying Trump challenging the election, which he's allowed to do, or was allowed to do until this indictment. He can't challenge it. All he has to do is his duty, okay? The president's duty is following the legal procedures for determining the election results and ensuring the power vests to the new president. And I noticed they didn't cite that. Is there a duty in the Constitution that says that the president just has to just say, okay, I guess CNN called it for Joe. That's the end of the story for us. What's the citation on that one? Is there a citation there? Where does that duty come from? Judges? It comes from you. They just made it up and shoved it in there. Now, the public has a strong interest in our government working. Of course we do. That's why we were so upset about a rigged election. The Supreme Court recently noted that the framers said a bunch of stuff about the president. Now here, former President Trump's alleged efforts to remain in power despite losing the election were, if proven, an unprecedented assault on the structure of our government. He allegedly, they say, injected himself into a process where the president has no role. He's the executive. And again, this is their discretion, right? Like the counting and the certifying of the Electoral College votes. He wasn't there counting them, thereby undermining the established procedures. Now, to immunize Trump would go further. And Judge Jackson wrote that and so on. And so we cannot accept Trump's claims that the president has unbounded authority to commit crimes. He has never made that claim. This feels like a blog post on some lefty blog that would neutralize the most fundamental check on executive power, the recognition and the implementation of election results. Trump never claimed he's got unbounded authority to commit crimes, never once. Nor can we sanction his apparent contention that the executive has carte blanche to violate the rights of individual citizens to vote and have their counts vote. It's great. No one's asking you to do that, weirdo judges. Now, at the bottom, former President Trump's stance would collapse our system, they say, of separation of powers, and it would place the president beyond the reach of all three branches. No, it would not. All you would have to do is impeach him for stuff that's within the bounds of his office. This is a wild thing. It's like, no, it would not. Like, even he said that in his oral arguments. I already played the clip for you. Presidential immunity against federal indictment would mean that, as to the president, that Congress could not legislate, the executive could not prosecute, and the judiciary could not review. It's just all like hyperbole. That doesn't even mean anything. We cannot accept that the office of the presidency places its former occupants above the law for all time thereafter. That's good, because nobody's making that argument. So I don't know who are you talking to? Careful evaluation of these concerns leads us to conclude that there is no functional justification for immunizing former presidents from general prosecution in general. And again, we're not saying that either. We're saying it's for his conduct while he was the president, or for immunizing former President Trump from the specific charges in this indictment. In so holding, we act not in derogation of the separation of powers, but to maintain their proper balance. All right, and the last section from these lefty judges, the impeachment judgment clause, and this is one that we've been really focused on, saying the strongest evidence against Trump's claim of immunity is found in the words of the Constitution, they say, which I can't even believe they read it. But the impeachment judgment clause provides, it says this, judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy those office, but the party convicted, ED, shall nevertheless be liable and subject to indictment, trial, judgment, punishment according to the law. So if you are convicted, then you're liable. Now they say that language limits the consequences of the impeachment to removal and disqualification, but it explicitly preserves the option of allowing other prosecutions according to law, right? So I think they just forgot about the convicted part of this. The language limits the consequences to removal and disqualification. So they just say, oh, that's the only, like, because this only limits you to removal, it shall not extend further than to removal from office or disqualification. I can't even believe these people know how to read, I got to tell you. So they're saying, well, that language limits the consequences to just removal and disqualification, which is true because it's Congress. But then After they are convicted, then they're nevertheless liable to other types of prosecution. Okay, it preserves that according to the law. So former President Trump agrees that the impeachment contemplates and permits the prosecution on criminal charges. He argues that such a former president must first be convicted, the ED. There, they got it. In other words, he asserts that under the clause, a former president enjoys immunity for any criminal acts committed while in office unless he is first impeached and convicted by Congress. Accurate. Accurate. Now, under that theory, he claims that he is immune from prosecution because he was impeached and acquitted, not convicted with the ED. By taking that position, former President Trump potentially narrows the party's dispute to whether he may face criminal charges, in this case consistent with the impeachment judgment clause. If the clause requires an impeachment conviction first, he may not be prosecuted. But if it contains no such requirement, the clause presents no impediment to his prosecution. So they're just going to read it out. They say Trump also concedes implicitly that there is no absolute bar to prosecuting assertedly official actions. Which is weird because like 20 pages ago, they said that he was making those claims, right? They said that up there. Trump is claiming he is absolutely immune. But now they're saying he's not. Now he argues elsewhere in his brief that it's same and closely related. So they're trying to determine what is an official act, right? You got to be within the confines of official acts, the outer perimeter, as they say. So you've got like clear stuff, which would be like, you know, a State of the Union, like giving the State of the Union. Okay, that's like no one's going to charge you for that. But here, challenging an election, like they say that's at the outer end. And so maybe that is official. If it's outside the hula hoop, it's not official. If it's inside, it's official. They say Trump was impeached and he was acquitted for the same and closely related conduct to this indictment. They literally charged him with insurrection in the Senate. They didn't do that here. And he agrees that if he had been convicted by the Senate, he would not be immune from prosecution here. They finally got the argument now, page 42. Thus, he concedes that a president can be prosecuted for broadly defined official acts if he actually is impeached. Great. Now, the impeachment judgment clause is focused solely on those who are convicted by the Senate following the House impeachment. The first part of the clause limits the penalties that can be imposed because it's Congress, right? They're not a prosecutorial office. Judgment in these cases is limited to removal. Now, the second part makes clear that the limited consequences do not immunize him from criminal prosecution. We got that. But in Trump's view, however, the word convicted in the second phrase implicitly bestows immunity on presidents who are not convicted. Right. Based on negative implication. They got it correct. He asserts that the impeachment judgment clause presupposes that a president is not criminally liable absent a Senate conviction. Now, other courts have rejected this tortured interpretation of the impeachment judgment clause. What other courts? Claiborne case. And they're talking about federal judges there. Okay. It's like, what cases are you talking about? Okay, this is a case of first impression. So why are you leaning on other cases from other districts that don't involve presidents? Now, moreover, former President Trump's interpretation runs counter to the text. The force of any negative implication, it depends on the context, they say. And so here they're going to give us some analysis. Good, explain this in themselves. Let's see. To begin, former President Trump's reliance on a negative implication is an immediate red flag. The framers knew how to explicitly grant criminal immunity in the Constitution. And so if they wanted to give him immunity, they would have just wrote it in there. Oh my gosh. Yet they chose not to do it because they did write it in there. It's called convicted. They didn't think they'd have to explain themselves to moron DC judges. The impeachment judgment clause merely states that the party convicted shall nevertheless be liable, but the text says nothing about non-convicted officials, right? So you have to read that in. Former president's reading rests on a logical fallacy, saying if the president is convicted, he can be prosecuted. But it does not necessarily mean that if the president is not convicted, he cannot be prosecuted. Now, which serves their argument, obviously. The whole point of that provision is to have a constitutional check, a safeguard, to make sure that it is apolitical. Okay, if both parties agree, both houses agree, then there was something really bad that happened. And if not, then it doesn't open the floodgates. Like if you can just do whatever you want with this, if it doesn't matter either way, why'd they put the whole provision in there at all? Does it mean anything? Does convicted mean anything at all? If you just say it means nothing, because you're saying it means nothing. So the text of the impeachment judgment clause reflects its purpose. It's to allocate responsibility between the legislative and the executive branch for people who are responsible for misconduct. Bunch of copying and pasting here, saying the framers chose to withhold such broad power from the Senate because they're not the executive. They are not the executive branch, specifying instead that the Senate could impose only political and not ordinary criminal punishments because they're the Senate. Now, the framers wish to make clear that a president would still be liable to prosecution. We know after he is convicted. And they're going back to the Federalist page. So, okay, we've read enough of this stuff at this point. Like, you know what the arguments are. And you can just pick and choose, which is exactly what they're doing. Now, as the Office of Legal Counsel noted, more copying and pasting. And in short, the framers, they say, intended impeached officials to face criminal liability according to the law. In short, then, the framers wanted impeached, doesn't have to be convicted, just if you're impeached enough is alone. They pull out this quote from Hamilton, Federalist 69, says the President of the United States would be liable to be impeached, tried, and upon conviction of treason, bribery, or other high crimes, then removed from office, and would afterwards then be subject and liable to prosecution. Now, Trump focuses on the words afterwards, which matches convicted, but they go to the English dictionary. And they say, well, it's, read the dictionary. Okay. Other historical evidence also supports our conclusion. Edmund Pendleton, president of Virginia, of the Virginia Ratifying Convention. He wrote some stuff about this. And in drafting this, to the extent that the framers contemplated whether impeachment would have a preclusive effect on future criminal charges, the available evidence suggests that their intent was to ensure that a subsequent prosecution would not be barred if you are convicted, as we've been saying this entire stinking opinion. They give us some more. They say, finally, practical considerations and practical consequences of Trump's interpretation demonstrate its implausibility. The impeachment judgment clause applies not just to presidents, but also to everyone else. Thus, his reading would prohibit the executive branch from prosecuting current and former civil law. So they just make it overbroad then. All right. If we give it to Trump, we got to give it to everybody. And then the whole world, and everybody's going to go murder everybody on the streets. Even if there is an atextual basis for treating presidents differently, which there is, from subordinate government officials, which there are, his proposed interpretation would leave a president free to commit all manner of crimes with impunity, so long as he's not impeached and convicted. Well, if he's committing crimes, just impeach him. Former President Trump's interpretation also would permit the commission of crimes not readily categorized by things that are impeachable. And if 30 senators are correct, basically he could just, hide and then leave office. Now, he also talks about double jeopardy. He says, alternatively, this is double jeopardy. I've already been tried once on this. And as we've discussed, the impeachment judgment clause addresses only convicted parties. It does not address the consequences of Senate acquittal. So in other words, if you are acquitted, they can still punish you if they don't like you. Now, for the reasons already stated, this does not bar prosecuting Trump because the clause simply doesn't speak to it. It's a negative indicator there. But the weight of authority supports our claim. Since it doesn't speak about it, right? They don't want to read into it. They want to go get out a bunch of other stuff. And they say under precedent that interprets double jeopardy, former President and Trump's at his impeachment, it does not bar subsequent criminal prosecution for two reasons. One, there were no criminal consequences from the impeachment. And the indictment does not charge the same offense as a single count in impeachment. Wow. So the impeachment was insurrection. Jack Smith was too cowardly to charge him with insurrection because he knows he can't prove that. But it is now not double jeopardy because it's not the same charge, is what they're saying. And impeachment is not criminal. So in order for it to be twice charged for the same crime, it's also got to be a crime. And so Trump's acquittal in the impeachment trial makes this point. A bunch of senators acquitted him not because of the offense that was even charged. They said, we have no power to convict him. I don't care what their explanation was. It wasn't enough to overcome the burden. Now, in light of very different procedures, right? A criminal trial is different than a political trial. One's in a court of law, one's in the clown house of Congress. So they say impeachment is not a criminal process and cannot result in criminal punishment. I think that's probably the best argument that they've got in terms of case law in this whole filing. But that's it. Now, Blockberger says, even if we assume that Blockberger is the free speech test, they say, oh, no, I'm sorry, that's Brandenburg. Blockberger is a double jeopardy test, very similar. Brandenburg and Blockberger. Blockberger says, you look at the elements of the crimes, and if they match up, like if like 3 elements match these 3 elements, and 1 element matches this, and but 1 element in each crime is different, you can be charged with both crimes. So here, it's not the same offense. Okay, one's insurrection, the others are conspiracies to obstruct official proceedings. So they're not the same. Now, Trump does not dispute this analysis, and so it's not the same crime. It's not the same conduct, and so double jeopardy doesn't apply. And I think, like as I said, double jeopardy principles are pretty hardened, and like we know what jeopardy is. That's codified, and so I think that impeachment does not protect against that. But you got to be convicted in order to bring that second charge. So he would still be precluded under the first step of that analysis. But they say in this so ordered opinion signed, not signed by any of those judges, they say all of this analysis, we have balanced President Trump's asserted interest in executive immunity against the vital public interests in favor of allowing this prosecution to proceed. And that's really the whole point of this whole opinion. That's it. Okay. They did a balancing test. The rest of this is backfilled, copy and paste case law, where they're not even logically consistent. Like they know what Trump's argument is, but they spend the first 2/3 of it arguing against a straw man, a made up argument. Trump says, hey, he's absolute immunity to murder Navy SEALs. He never said that at all. They get down to this section. We conclude that concerns of public policy, especially as illuminated, compel the rejection of his claim, and immunity in this case. It's just their public opinion. It's their public opinion. It's their public interest. It's not ours. It says, we also have considered his contention that he's entitled to immunity for official action that he took, a contention that is unsupported by precedent. And finally, we are unpersuaded by his argument that this prosecution is barred by double jeopardy. And so accordingly, Judge Chutkan and her decision is affirmed. Big surprise. We're not actually surprised at all. We know this was coming, but now it's up to the Court of Appeals, to the Supreme Court. And this is a fun footnote. They say, by the way, amici, former Attorney General Edwin Meese and others, they say Jack Smith is invalid. And looks like they're not really going to address this. They say no statute authorizes Jack Smith, and he's a principal officer who must be nominated by the president and confirmed by the Senate. But we generally lack jurisdiction to consider issues that do not independently satisfy the collateral order doctrine. This is a great question that came up on our locals this morning. In other words, can this disqualification argument go in front of the Supreme Court? And I think the answer is yes, because they can, if they want to hear it. Because the Appointments Clause issue was neither presented nor asked to be decided by this district court, there is no order on the issue that could even arguably constitute a collateral order for us to review. So, right, Supreme Court has original jurisdiction, like they're SCOTUS. They can do whatever they want and just craft rules. But this court is saying we can only really take what Judge Chutkan gave to us. So additionally, the exercise of jurisdiction would be improper, assuming without deciding that even the jurisdiction is ever available in criminal appeals. So we would not be able to handle that at all because this, file that in a different case. So that issue is going to be curious to see if that's addressed at the Supreme Court. And of course, the Supreme Court, they have oral arguments in 2 days from now. So make sure, my friends, you're subscribed here because we're going to be covering that and unpacking all of this. But immediate impressions were, this is not what a lot of people on the left are saying. They are screaming about this huge victory for the left. Yeah, this anchors in the constitutional decision and so on, and it's going to get just they're saying it's going to either be rejected by the Supreme Court or the Supreme Court is going to accept it and then affirm this. I don't think that's either one of those is true. I think there's a lot of bad logic in here. They're even inconsistent in their own analysis. So that is the full opinion. Now, another question that's coming up is about what is this going to do to the timing? And this also came out simultaneously. We got some reaction to this. But this case, they said it came to be heard and it's been ordered and adjudged that the lower case is appealed and affirmed. They say, though, the clerk is directed to withhold the issuance of the mandate. Okay, so this has to go back down to Judge Chutkan, but withhold it through February 12th. And as soon as Judge Chutkan gets it, she's scheduling a new trial date and this thing's back on track. If within that period, Trump notifies the clerk that he's filed an application with SCOTUS, then we're going to stay that pending what happens with SCOTUS, pending the filing of a petition. So as soon as Trump files this on the 12th, it stays everything. Then the filing of a petition for a rehearing, they say if he wants to go back to the full panel at this Court of Appeals, it's not going to result in the withholding of the mandate. So if he asks the full court to hear it, too bad. Chutkan can still keep the train back on the track. Now, the filing will not result in the withholding, but if they grant a rehearing en banc, then they will recall the mandate if the mandate has already issued. Okay, so if the full court takes it, then they'll stay it again. So that's what happened from the Court of Appeals, and there's questions about that. What is the timing going to look like? Kyle Cheney, he writes from Politico, covers this stuff pretty aggressively. He did some calculations for us. He says, all right, the D.C. Circuit Court took 55 days to take up the case. December 13th, they resolved it on the 6th. If SCOTUS goes at the same pace, about 2 months, and rules the same way, that would mean we get a SCOTUS decision in April. Chutkan says that she's going to give Trump the same amount of time to prep. So if we go from December to April, if we go from December to April, how many months is that? Then we say, okay, we're back in April. So December, January, February, March, April, that's 5 months. We're back in April. And then we get another 5 months. Woo, so that says we could be putting that back into late July or early August for a trial date. And we already heard Judge Chutkan, she's ready to go. I think she's ready to have a trial at that time. Jonathan Turley also had a similar comment on this. Says, let's crunch some numbers on this. Says Trump can seek corrections in the short term, but even without a correction, he's got 45 days to seek an en banc. But they don't care about any of that, right? He then has 90 days after the en banc is rejected, but they're going to keep this thing on track, right? But let's say Trump appeals that issue. So even without factoring in time for the review for the circuit, Trump could extend this process 135 days, absent a successful move to expedite by Jack Smith. The 90-day period would put the petition into May. Any rejection of appeals without an expedited calendar puts this into the summer. He says that is without delays or a successful grant by the D.C. Circuit, unlikely, or the Supreme Court, uncertain. Like what happens if SCOTUS just says, that's good enough for us, we don't want to deal with it. And that's my biggest concern on this whole thing, is that the Supreme Court also does this. Well, we're not going to see this problem again. Okay, if they're not going to see the problem again, they're like, well, we'll just let that one stand. We just decline to hear it. Trump gets prosecuted. They just let the people, deal with it there, and saying this issue's never going to repeat itself because they're not going to do this to other presidents. We'll see what the court does. Now, the question is why SCOTUS would suddenly see a need to accelerate all this. And Turley's basically saying he's not so sure that a trial is going to happen before the election. And I'm not sure if it is either. But let's see what else he said. Yeah. He said the D.C. Circuit adds a wrinkle on scheduling by saying that Trump only has until Monday, the 12th, to file with SCOTUS. The standard rules allow Trump 90 days. So why'd they only give him a couple days, 1 week? If he doesn't, then the mandate returns back to the district court. Judge Chutkan restarts all this. Then there will be emergency motions. Maybe there's an appeal on that issue. And, the whole thing is, here's what his conclusion is. If not months, if everything breaks for Smith on the calendar, he could still secure a pre-election trial, but he's facing diminishing odds. And for some reason, I feel like they're going to squeeze it in. I feel it. I feel it. Here is what Shipwreck Crew said. He said that, yeah, they're singling Trump out. And of course, we know that. Even the DC Circuit is doing it, saying, I now suspect some judges might be happy. I now suspect that some judges might again be unhappy about the procedural games that the DC Circuit Court of Appeals was making in altering the rules. Rather than follow the rules that we heard from Turley, they gave Trump 6 days to seek a stay from SCOTUS. And they state here, unlike every other case, that filing a motion for rehearing won't delay the issuance of the mandate. But for every other case, it does. How come they're doing that now? It says, I think this might land flat, just like Smith's efforts to bypass the appeals court. Like, courts are not going to be happy about that. Why don't the ordinary rules ever apply to Trump, just like everyone else? Well, it's because he's Trump. That's from Shipwreck Crew over there on X. And we had some reaction. Mike Johnson got asked about this very briefly as he was waddling out of Congress with the rest of our leaders, so-called. And here's what he got asked about from CNN.
The Federal Appeals Court today just ruled that President Trump does not have immunity. Do you think that he deserves total immunity from anything that he's done in office?
I haven't seen that development. Was that this morning?
Yeah, they just ruled this morning.
I believe that they've been after President Trump for partisan political purposes. I think that's obvious, and we call it lawfare, and I think there's no other way to describe it.
How did you go about picking your impeachment? Federal Appeals Court today just...
So lawfare, I think that's accurate. Sorry about the high volume on that. I didn't realize they were going to blow out our eardrums with an airplane jet engine, but they did. We also have this gentleman who is over in Washington, D.C., explaining his take on this. And this is a representative called John Rose saying Trump had every right to contest this election. And he's right about that. That's his job.
The fact is, President Trump had every right to peacefully contest the results of the 2020 election. Hillary Clinton did it. So did many of my Democratic colleagues in 2000, 2004, and 2016. The rules are clear and simple. They're written in Article 2, Section 1 of the Constitution and in the Electoral Count Act of 1887. It's how our process works. As a former practicing attorney, I can say there isn't a single shred of evidence that points in the direction that President Trump participated in an insurrection. The fact...
No, there isn't. And when they use that word, they throw it around. You really want to be clear what that means. Like, what did they have weapons? How long did it last? Were there casualties there? Was there an actual, seizure of property and control for a certain period of time? What was it that really led you to believe that there was an attack on the country, honestly, rather than a short riot that was instigated by the feds? Well, Trump has an obligation to take care of the country under the constitutional provision that obligates him to do that. Challenging a rigged election is part of that duty. So here is what Trump said in response to this. It says, as president of the United States, a president must have full immunity in order to properly function and do what has to be done for the good of the country. A nation-destroying ruling like this cannot be allowed to stand. If not overturned, as it should be, the decision would terribly injure not only the presidency, but the life, breath, and success of our country. A president will be afraid to act for fear of the opposite party's vicious retribution after leaving office. I know from personal experience because I'm going through it right now. It will become a political weapon used for election interference. Even our elections will be corrupted and under siege. So bad and so dangerous for our nation. Save presidential immunity. And so I'm sure Trump will be appealing this. Question is when, what's going to be inside. We're going to be here to continue to cover this, my friends. They are pulling out all the stops, and this is not a surprise, right? We knew that these judges were going to vote accordingly and rule accordingly. Just, look at them. But that is what happened here. They are not even being honest about the arguments that are even being made. They are showing us who they are, and I'm looking forward to watching it all crumble around them. Their arguments are not even good. It's going to be fun to continue to unpack them. I hope you join us as we do, my friends. Thank you for being here. Don't forget to subscribe wherever it is you're watching this. We got a bunch of links down in the description below, including our lodge, our Watcher Lodge, watcherlodge.com. We got a bunch of activities coming up in February. We'd love to see you join us. We got our survival squad build out. We've got a scanner unboxing for some over-the-airwaves monitoring. It's going to be fun. We've got a Zen wellness workshop that's going to be a lot of fun. So come check it out. Come join us, all free for the first 48 hours when they're live. So come and join us. WatchYourLodge.com. Links are in the description. And if you want any PDFs, you can find those at robertgovea.com. We're going to see you right back here on the next one, my friends. All right. That's Judge Chutkan. That's Washington, D.C. But now Trump is responding, and we're going to see what his response is to another issue, to another case, not responding to that case. And for this one, we got Crazy Eyes Griswold in the house. So let's just get right to it, shall we? Once I get the screen properly situated. In Colorado and SCOTUS. Donald Trump blasts Crazy Eyes Griswold, and the ballot removal team at the Supreme Court of the United States were getting ready for oral arguments. And you remember the secretary from Colorado, Jena, she's going to be arguing in front of the Supreme Court. She's got a full 10 minutes. Her team is going to be there. Maybe she'll speak. Maybe someone else will. I don't know. But here on February 2nd, SCOTUS said, in anticipation of this argument over whether Trump is going to be removed from the ballot in 2024, that the Supreme Court's going to decide any minute, they said that Crazy Eyes is now getting 10 minutes. Granted, a total of 80 minutes is allotted, 40 minutes for the petitioner, that's Trump, 30 minutes for Colorado, and 10 minutes for Crazy Eyes Griswold out of Colorado. So she's going to be there to talk about this. But remember, they're trying to throw Trump off the ballot. They said that he's an insurrectionist. The 14th Amendment applies. They had a little fake hearing in Colorado. The Supreme Court of Colorado, 7 Democrats, all threw him off the ballot. In my opinion, they shopped the forum. They shopped the courts. This was their number one target. They got it done. Trump is appealing this to stay on the ballots. They say they're saving American democracy by throwing him off. But Trump is challenging this, and this is his final reply before the oral argument starts. So we're going to go through that, see what's inside, and see what Congress says, because Matt Gaetz and Elise Stefanik have submitted a resolution saying that Trump is not an insurrectionist, and they're saying we should officially rule on that in Congress. But here is what Jena Griswold, Crazy Eyes, before we read her, what was said in response to her attempts, this is what she said when she was out in the media. And what's funny about this one is that she posted this one for us to see. She's very excited about her position and her role as the person who's saving American democracy by keeping people off the ballot. She posted this on her X account, and here's what she sounds like.
So, Secretary Griswold, just to be clear, you've been very careful on this issue. You didn't just come out and pound the table on this from the beginning. You know, for months, even on this show, you did stop short of saying Trump should be kept off your state's ballot, even though you did believe he incited an insurrection on January 6th. So you don't come to taking this stand and going before the Supreme Court lightly. Why? How did this happen that you've decided now to take a different and very clear public stand?
Like you said, I've always believed that Trump incited the insurrection. But it was pretty clear that regardless of my personal thoughts, a court was going to decide, did his actions reach the level of disqualification under Section 3 of the 14th Amendment? And a court has. The Colorado Supreme Court looked at all the district court's findings, spent a specialized amount of time, and determined he did engage in insurrection. And that on top of that, the Constitution applies to the president. There's no get out of jail free card for insurrection for Donald Trump. And honestly, Aaron, I think they got it right. And I'm making this clear statement in protection of Colorado law, because I think that's how the Constitution should work. Section 3 of the 14th Amendment is there to protect the country from insurrectionists like Donald Trump. And I hope that the United States Supreme Court looks at all the facts, all the case law, and the clear words of the United States Constitution in making their determination.
Yeah, we have the 14th Amendment. The insurrection clause doesn't apply to the president, but you know, that's easy for most people to read. It's just in there. It just says that, right? It skips right over that position. But that's the person, okay, regardless of what happens at the Supreme Court, she's going to be running the election. She's the Secretary of State, and she's not alone, okay? She's just a caricature of many of the other secretaries who are out there in all the various states, like Shenna Bellows in Maine and Jocelyn Benson in Michigan. They're the people, like maybe we don't care about Maine, okay? Maybe we're going to lose Maine. It's going to go blue. Maybe Colorado goes blue. What about Michigan? Maybe there's a play for Michigan, and we got Jocelyn Benson there. All right. So you see it's a problem regardless of their dilapidated logic about the actual foundation of their claim. They're also going to be in charge of running the numbers. They're keeping score. They're the scorekeepers for the next election. And this is how they talk on MSNBC. So she's going to be in front of the Supreme Court at some point. And this is what Trump submitted as his final reply before the oral arguments start. In the Supreme Court of the United States, Donald Trump versus the ballot removal people, the people trying to throw him off the 2024 election ballots. This is Trump's final reply. Remember, he submitted his petition. The Colorado litigants, the people trying to get him off, they responded, and now Trump submitted his reply. It's in front of the Supreme Court. Oral arguments scheduled for Thursday. They write, in reply, in the Supreme Court, dear judges, Trump's team says, all right, SCOTUS, President Trump won the Iowa caucuses, in case you missed it, with the largest margin ever for a non-incumbent. And then he won the New Hampshire primary with the most votes of any candidate from either party. He is the presumptive Republican nominee, and he's the leading candidate for president of the United States. Even MSNBC is admitting the polls are bad for Joe. And they say, in our system of government, of the people, by the people, and for the people, the American people, not the courts or election officials like Griswold, should choose the next president of the United States. And as this court has explained, the right to vote freely for the candidate of one's choice is the essence of a democratic society, and any restrictions on that right strike directly at the heart of representative government. So they want to call Trump an insurrectionist. Trump never tried to remove anybody off the ballots. Yet at a time when the United States, and this is official policy, Biden is threatening sanctions, literally, against the socialist dictatorship in Venezuela because they're excluding the leading opposition candidate for president from the ballot, footnote 2. Karine Jean-Pierre, she even had a press briefing about this. U.S. government pulls some of Venezuela's sanctions relief after the court blocks an opposition candidate. Okay, a court threw out a Venezuelan candidate. United States reimposes some sanctions. We do it here. They say we're saving America. Respondents, the litigants, they ask this court to do the same thing. Now, to date, at least 60 state and federal courts throughout the country have refused to remove Trump from the ballot. The Colorado Supreme Court is the lone outlier, and this court should reverse it. And for reasons below, and to protect the rights of millions of Americans who want to vote for Trump, you should throw this case out. Now, they get into this main argument that we've seen a lot about and talked a lot about here. Is the president an officer of the United States? And this is what Section 3 says. There are lists there. Officers and offices. Neither of the lists expressly mentions the president. Now, the Colorado litigants would have us believe that the president is tacitly subsumed within a generic catch-all phrase called, quote, officer of the United States, an office under the United States. But she cannot overcome the overwhelming, talking about crazy eyes, the overwhelming textual and structural evidence that, quote, officer of the United States as used throughout the Constitution refers only to appointed and not to elected officials. And Crazy Eyes' arguments that the presidency qualifies as an office also fails to persuade us. Now, Anderson, the litigants, insist that every person who holds a federal office is an officer of the United States. Every single person. But that is wrong, because the Speaker of the House and the President pro tem of the Senate are officers and hold federal offices, yet they cannot be officers of the United States. Why? Because they're not subject to impeachment, and they're not commissioned by the president. Now, unless Anderson is prepared to throw out those cases and subject them to impeachment, because the other cases said that they're not, then she must concede that the officers of the United States refers to only a subset of federal office holders. And the only sensible construction of that phrase in light of the appointments clause, the commissions clause, and the impeachment clause is that, quote, officers of the United States, officers refers to appointed federal officials, and it excludes other officials like Speaker, President pro tem, President, and Vice President. Now, Colorado, the litigants, they reiterate their claims that Section 3 establishes a symmetry in pairing barred offices with excluding individuals. That's also wrong. That, one, members of Congress, in quotes, it sweeps more broadly than senator or representative in Congress. Member of Congress is more broad. Section 3 also prohibits disqualified individuals from serving in the Electoral College, and it doesn't disqualify former electors who engaged in insurrection. And 3, the canons of construction, okay, how the statute was written, how the 14th Amendment was crafted, counsel against giving equivalent meanings to differently phrased provisions. So just don't say it's close enough so it counts. Now, the Colorado people don't deny any of this. But Griswold tries to get around these admitted asymmetries by observing that the electors and non-voting members of Congress are not constitutionally required to swear oaths, but non-voting delegates have always sworn an oath, even though the article doesn't require it. And Section 3, under the 14th Amendment, turns on whether an oath was previously taken, not on whether it was constitutionally compelled, right? So some very, very detailed nuance there. So Anderson cannot establish the symmetry that she insists upon, and so there's no basis for demanding correspondence between officers and office. So it's just, she's making it up. But then she tries to get traction. She can't figure it out in the Constitution. So she tries to step outside of the Constitution, and she tries to use the word officer in the colloquial sense of the word. But none of this purports to interpretate what the Constitution actually says, and none of it can alter or affect the constitutional meaning of the phrase. President Johnson cannot make the president into a constitutional officer because he described himself that way. He's well, I'm kind of an officer. That doesn't make him an officer. Any more than Congress can change the meaning of the 14th Amendment by enacting a statute. And no proclamation or floor statement or court opinion can override the fact that elected officials, including the president, cannot be characterized as an officer of the United States for 3 reasons. 1, they're not commissioned by the president. The president doesn't commission himself. They're not appointed pursuant to Article 2, as the Constitution requires. And they are excluded from civil officers described in the impeachment clause. Now, they try to get around addressing this. They get around to addressing it. And when they do that, they claim that the commissions clause means only that the president alone has the power to grant commissions. But that's not what it says. The language says the president alone may commission the officers of the United States. It says that the president shall commission all the officers. Okay? It doesn't say this, that the president may alone commission. That's not what it says. It says shall commission all, meaning all. Shall means must, all means everyone. That's what the words mean. And when the Constitution requires every officer of the United States to be commissioned by the president, that means anyone who is not constitutionally required to be commissioned by the president cannot be an officer of the United States. Now, Anderson tries to get around that also in the appointments clause. Anderson insists that this caveat refers only to appointments. So basically, they're trying to, knock out all of their responses, and they're replying to their responses, saying that their interpretation here is wrong for many reasons. 1, the president is not appointed by the Electoral College. There's no appointments there. He's elected, so it doesn't fit. And only an appointed and not an elected official can be an officer of the United States. There's prior Supreme Court case law for that. House and Senate members, for example, are elected rather than appointed, so they cannot qualify as officers of the United States. The Constitution also consistently describes the president as elected and not appointed, and he cannot be regarded as an officer for the same reason. But their stance is talking about the senators, talking about the emoluments clause. They argue if this court holds that presidents and vice presidents are appointed, then any senator who became president or vice president before the expiration of a 6-year term will have served in violation of the Constitution if the president or vice president's salary had increased under the appointments clause. So it create a logical inconsistency. It would also empower Congress to strategically disqualify sitting senators from the presidency by voting to increase their salaries, because the emoluments, right? They're going to commingle. Now, even if the president could somehow be described as appointed rather than an elected official, he still cannot be characterized as an officer. He doesn't receive a presidential commission. He is listed separately from civil officers in the impeachment clause. The Speaker of the House and the President pro tem of the Senate cannot be squeezed into an otherwise provided for caveat. They're pretty important positions. You can't just shove them into some category. And third, Anderson is also wrong to claim that our interpretation leaves the, quote, otherwise provided for caveat without any work to do. The Constitution does provide for appointments of inferior officers. Anderson also claims that the impeachment clause lists the president and the vice president separately to avoid confusion, but this does not explain why the impeachment clause omits the word other before civil officers of the United States. They say that Anderson says that Trump's interpretation of, quote, officers of the United States will exempt the president from the oath requirement. But the first Congress enacted legislation requiring the president to swear the same oath as everyone else listed in Article 6. And a statutory oath requirement can reach beyond those mentioned in Article 6. So the absence of an explicit oath requirement for the VP doesn't make him an officer. It's also hard to accept the Colorado litigants, their construction of officer of the United States, when Section 3 covers only those who swear an oath to support the Constitution. So this is the oath, right? The officer's oath versus the presidential oath. Officer's oath says support the Constitution. Presidential oath says preserve, protect, and defend. They're just saying, well, it's kind of the same thing. They kind of mean the same thing. So one is interchangeable with the other. But then she needs to explain why the drafters of Section 3 would create this ambiguity by using the word support and exclude any reference to the presidential oath. So the 14th matches the officer's oath, not the presidential oath. If they said the president needed to be included in there, shouldn't the oath match the presidential oath? They had it match the category that they wanted to apply it to. They say Anderson is also wrong to say that Trump's interpretation defies common sense, they say. It was entirely sensible for Section 3 to exclude the president as a covered officer. Why? No ex-president supported the Confederacy except John Tyler, and John Tyler died in 1862 at the time of the war. Each of our 46 presidents except George Washington and Donald Trump would be covered by Section 3 because they held a previous job listed in the amendment. So yeah, each of them would be covered except George Washington and Donald Trump. Interesting comparison. That's an interesting fact. Isn't that interesting? Only George Washington and Donald Trump. Isn't that interesting? Interesting fact that they both have. They have this in common. And former presidents, they have in common that they never held a prior job. Would be covered by Section 3 because they held, like, a senator or something else. Interesting. Trump and George Washington. Man, the liberals probably hate that one. And 3 former presidents rarely seek election or appointment to office. An overwhelming majority retire from public service. So indeed, Anderson's construction of a Section 3 will allow the courts, if you listen to them, to eject a sitting president from office. Now, apart from the impeachment process, if a court independently determines that he has engaged in insurrection, even if Congress refuses to impeach and convict on that ground. And so finally, they don't even mention this very important case. And that case makes clear the president is not an officer of the United States. They tried to describe the presidency as an office, but that's wrong. Anderson's construction of the word office under the United States is wrong. The Speaker of the House and the Senate are officers who hold federal offices, but neither holds an office under the United States because the incompatibility clause bars the House and the Senate from holding such an office, right? It's all technical distinctions here. Now, Anderson says, it's clear, and you're not supposed to use that word in legal writing. If it's clear, then explain it. Don't use the word. That office under the United States includes the presidency. It almost means that your arguments are going to fail. Anytime you say it's absolutely clear, just explain it. But the evidence is far from clear. The most troublesome evidence for Anderson, Section 3 doesn't even mention the presidency. It's not even listed in the covered offices, but it does specifically enumerate senators, representatives, electors for president and vice president. But it excludes the president. Weird. And a draft of Section 3 that was introduced by a representative called Samuel McKee explicitly listed the presidency and the vice presidency. So first draft says president. Then they deleted it. Yet this was rejected in favor of the enacted language, which omits any mention of the presidency. And instead, right, we're not talking about the president. We're disqualifying the individuals from serving as electors, right? The people who would elect the president. If you've got a question about their loyalties and whether they swore an oath or not, then they've got to go. So that's a mechanism by which they can protect against insurrectionists under the 14th, back during an actual civil war that lasted years, resulted in hundreds of thousands dead, not 4 hours, then that would give you some protection against insurrectionists usurping that role. And they put that in there for a reason. That's the safeguard. So the Colorado Supreme Court tried to explain this. Why'd they put that in there? They said, well, senators and representatives and electors do not hold offices under the United States, and therefore they needed to be separately enumerated. But it was at least debatable whether that phrase would encompass the presidency, especially when the phrase officers of the United States excludes the president every time it appears in the Constitution. So one would expect the text would mention the presidency if it overcame that other default. And they also tell us, this is pretty obvious. Anderson claims that the events of the Capitol were an insurrection and that Trump engaged in an insurrection by supposedly inciting the crowd. Inciting the crowd, right, was the insurrection. He just incited them. Okay. This is wrong on every count. There was no insurrection. Trump did not incite anything, and the president did not engage in anything that constitutes an insurrection. Now, first, and this is the basis for them keeping him off the ballot. First, the events of January 6th were not an insurrection, as they did not involve an organized attempt to overthrow or resist the U.S. government. And by the way, no one's been charged with insurrection. So if they thought that, which is on the books, there is a statute for that. They did prosecute the Proud Boys and the Oath Keepers, but that was for seditious conspiracy, not insurrection. Now, events of January 6th were not an insurrection. They lasted about 3 hours. Most participants were not acting on any plan. They acted on a spur of the moment. Few, if any, like a handful, carried firearms, like weird, no firearms. And their objectives were narrow. They were there to pressure Congress and the vice president to correct what they were after. They thought that there were fraudulent election returns. They wanted an investigation. And even Ted Cruz was there, like calling for this. Not an insurrection. Now, second, Trump did not incite anything. So it wasn't an insurrection in the first place, but incitement, that doesn't apply either. He didn't incite anything. He told his supporters to fight like hell, march to the Capitol, take our country back. But even the district court acknowledged that language of this sort is prevalent everywhere. The president's statements are far less provocative and definitely falls short of incitement under Brandenburg. Anderson says Trump's tweet was a problem, but that tweet did not call for any action at all. It was also sent over an hour after disorder broke out. So how could he have incited something if they're upset about his tweets that came after? So the district court had to rely on Professor Seamies, this is back in Colorado, some professor, to say that Trump communicates in coded language, right? It's like a dog whistle for you MAGA supporters out there. Trump says go peacefully and patriotically, and you just want to start burning things like it's a BLM summer of love. Except there were no third precincts of Minneapolis that were burnt to the ground, unlike their riots. And Kamala Harris was supporting them getting out of custody. Can we bail these people out who torched a police precinct? Remember all that? Trump, no, none of that happened, obviously. But it's coded language to push Trump's speech into the incitement category. And Anderson now tries to downplay the role of his testimony, but she has nothing apart from Simi that can convert Trump's statement, which would be otherwise constitutional, if uttered by any person, now suddenly become criminal because it's incitement. And third, even if there had been incitement and insurrection, which there's not, Trump still did not engage in it. Incitement, which did not occur here, is not engage. You can follow the bouncing ball, right? Because a person who incites seeks only to bring about imminent lawless action. Trump didn't want to do that at all. Not at all. Not all lawlessness rises to the level of insurrection. There are things called riots. And the district court found only that Trump's speech and tweets, they incited imminent lawless violence, not that they incited anything that's an insurrection. So even incitement of insurrection would not be enough to constitute engagement of insurrection, because incitement turns on whether a person's speech is directed towards or likely to produce, whereas engagement is actual participation. So it's an even higher standard. Now, Trump is not arguing that engagement requires personally committing the violent acts, but he's arguing that none of his actions, including his speeches, none of his social media posts, none of this qualifies as engagement in an insurrection. Now, none of the authorities cited by Anderson that include incitement as engagement involve speech or conduct of the sort that Trump is alleged to have committed here. And finally, the court should not apply the clearly erroneous standard to constitutional facts or mixed questions of law. Clearly erroneous, right? Saying that we're just going to defer, in other words, to the lower courts. And we're only going to overturn Colorado if we decide that it was clearly erroneous. Like it's a high standard, right? We defer to the lower court rulings. We leave them settled if we can. They say that is important. That's the appropriate standard for basic. They say the district court's findings involving Trump's mens rea should be reviewed independently. Why? No witnesses claim to have firsthand knowledge of Trump's intent or thought process. It's all conjecture. The trial court is in no better position than this court to determine Trump's state of mind based on the evidence that was presented there. And lastly, Section 3 should only be enforced of the 14th Amendment through Congress. It's not self-executing. Trump is not arguing that Section 3 is non-self-executing. His claim is that Section 3 may be enforced only through congressionally enacted methods of enforcement. Now, the litigants from Colorado, they do not deny that congressional implementation can implicitly preclude other means of enforcing this. But regardless of what they think, the fact remains that it was the only judicial decision in place. That we don't like this case law, but it's the only case law that exists. Now, Anderson notes that the Insurrection Act, the only surviving piece of congressional legislation that was enacted before the 14th, sweeps more broadly than constitutional disqualification. And if we accepted their arguments and their interpretation, that means that Trump could not constitutionally serve as president after J6, right? Like after January 6th, that's it. It's self-executing, and there's nothing we even need to talk about. It just happens. So he would have automatically been disqualified after the 6th. So they say Section 3 cannot be used to deny Trump access to the ballot. This is another interesting point. Anderson argues that Colorado can exclude Trump from the ballot if they conclude that he is presently disqualified. But that's not true. The law says it's about holding office. Anderson's stance is indistinguishable from some other cases, and they ignore these other requirements. None of the other rulings they're relying on would allow them to deny ballot access to candidates whose qualifications are contingent upon future action. So they're wrong to say that Trump is presently disqualified. Section 3 is a prohibition only on holding office, okay? So you can run for office. Congress can waive this prohibition. So no court or litigant can declare that Trump is presently disqualified from holding office. He hasn't won it yet. He's got to run and win. Anderson may believe or hope that Congress will not waive Section 3 between now and January 20th, but neither the Colorado Supreme Court nor this court can declare a candidate ineligible for the presidency now based on a prediction of what Congress might do in the future. And so finally, Anderson invokes the Electors Clause, but neither does this or anything support that they can alter their elections, saying the Colorado Supreme Court actually did violate the Electors Clause. Anderson makes no attempt to reconcile this other language, and so therefore, Trump's team says the judgment should be reversed in the state of Colorado, and Trump should be allowed to be on the ballot, which makes, logical sense if you live in a democratic republic. But Crazy Eyes Griswold and the 7 Democrats, they want to keep him off because they're concerned that he's going to win. And I think they're right about that. Their concerns are well-founded. I think he is going to win. But here is the final reply from Donald Trump to the Supreme Court. Oral arguments are scheduled on Thursday, February 8th, and we're going to be covering those here on the show after they are completed. But there's other actions in Congress. Matt Gaetz is saying, speaking about this insurrection problem, how about we just declare that Trump is not an insurrectionist? And here is what Matt Gaetz says in D.C.
But we are here today to authoritatively express that President Trump did not commit an insurrection, and we believe Congress has a unique role in making that declaration. It's not the job of the states, and especially not the job of some bureaucrats in Colorado, to make this assessment and interfere with the rights of voters to cast their vote for the candidate of their choice. The very experts who often get on television and talk about securing democracy seem to be the first to want to then remove a candidate from the ballot because they are afraid that he is too popular. We have 63 co-sponsors to the resolution that Ms. Stefanik and I will be filing today to express the sense of Congress that President Trump did not commit an insurrection. I want to express my gratitude to Senator Vance for filing the companion legislation over in the Senate. And now is time for members of the House and Senate to show where they stand on this question. We and the former president welcome and expect many more co-sponsors in the coming days and look forward to a floor vote. And now I'd like to recognize my co-lead on this project, our terrific Republican Conference Chair, Elise Stefanik.
All right, we're going to listen to her in a quick second, but it's an interesting thing, right? They're relying on Trump being impeached but not convicted as evidence. They're saying, well, he was impeached. A bunch of people in the House of Congress did impeach him and say he did do something with an insurrection. And so they said that was kind of good enough. We saw that come up many times in the prior filings. So what happens if Congress comes back out and says, actually, no, there was no insurrection, and that's congressionally dictated? I think that would be useful. My concern is, what if they don't get it done? What happens if they come back and they find that he was an insurrectionist via a resolution? What does that do? I don't know. I don't know that it does anything, to be perfectly honest, because my standard is impeachment and conviction. But this would, I think, create some gap for the domino effect. And I think it might actually stop some of the domino effect, because then they could say Congress has made this conclusion. All right, so that is what Matt Gaetz says. Now, here is Elise Stefanik. She came out and she added a little bit of meat to those bones. Here's what she says.
The American people are smart. They know that the weaponized attacks of radical far-left prosecutors and Joe Biden's Department of Justice against President Donald Trump are nothing more than a targeted political witch hunt used to further their own extreme far-left political agenda and hijack the will of the American people come Election Day. As President Donald Trump continues to dominate in the polls, extreme Democrats will stop at nothing in attempt to prevent President Donald Donald Trump from returning to the White House, and the Democrats are shredding the Constitution in the process. Joe Biden claims that democracy is on the ballot, yet the American people know that it is Joe Biden and Democrats who are openly attacking democracy. I am honored to stand as an original co-sponsor on Congressman Gaetz' resolution that President Donald Trump did not engage in insurrectional rebellion against the United States. That is a fact. Rogue far-left Democrat operatives are attempting to use this lie to illegally take President Trump off the ballot. This week, the Supreme Court will begin arguments in Trump v. Anderson to determine if liberal activist judges have the right to erase Donald Trump from the ballot, steal the election, and the American people's right to elect our leaders. For the sake of American democracy, I am proud to fight for President Trump and the tens of millions of American patriots who face political persecution. With that, I'm honored to turn it over to Bill Posey, our colleague who is also a co-sponsor of this bill.
All right, so some action from Congress. We'll see if it, gets any steam behind it or if it matters. I think it would be a slim victory in the House. Obviously, the Senate's going to have a different opinion on that. J.D. Vance entered in a companion bill. Senate's not going to vote against that. So it's probably just a little bit of some political gamesmanship, which is not necessarily a bad thing. I think that it's time for more of our congressional so-called leaders to pick a side on this, right? Are you okay with this Justice Department doing this? Are you okay with the courts doing this? Many of them ignored it. Many of them during the Republican primaries ignored it. We're not accepting that anymore. Time to make a decision. Do you stand with the corrupt DOJ or not? Elections are coming up. Make your voice heard. Stand up for something. And we'll see if Congress does that. Some of them did. Shout out to Matt Gaetz and Stefanik. So we'll see where it goes. My friends, we're going to be here continuing to cover this. The SCOTUS oral arguments are coming soon. We're going to see what happens with Crazy Eyes Griswold and the rest of the litigation at the Supreme Court. Thank you for joining us as we do. Don't forget to subscribe and to like this video wherever it is you're watching this. We got a bunch of good links down in the description below. We've got watchyourlodge.com, amazing events in February. So make sure you go to watchyourlodge.com. Check the community calendar, sign up for an event. They're free for the first 48 hours. So come and join us live before they go into the Lodge archives. So come check it out. If you want to grab the PDF that we read through, robertgovea.com. Also linked down in the description below. Grab yourself a hat, grab yourself some gear from the store, sign up for the daily newsletter, and we'll look forward to seeing you back here on the next one. All right, my friends. Well, that is it for us on the day. And we covered some good ground. Anti-Democrat ballot removers in Colorado going to be at the Supreme Court, and Trump's immunity was rejected in the D.C. Circuit Court of Appeals, but we're going to hear from them going up to the Supreme Court, I'm sure. But now, my friends, it's time to hear from you. We are going over to watchingthewatchers.locals.com. It's our members-only community. We do after parties after the show here. We do members-only streams in the morning. We do Saturday shows. We would love to see you. Come check us out. watchingthewatchers.locals.com. We got who's joining us today. We got some new supporters in the house. What's up? Who's coming in? Daisy at Nip is here. What's up, Daisy? And hey, if you're a YouTube supporter and you want to access the Telegram link, go to the community tab section, scroll way back like 4 or 5 months, grab the private members only Telegram link. We'll see you over there in the after party on the member only streams and on the Saturday shows. We got Bayou Billy's coming in. Welcome aboard, Bayou Billy. Carol Murray's coming in. We got some supporters coming in. What's up, Carol? We got Third Proverbs in the house. Good to see you, Third Proverb. Welcome aboard as a supporter. Our friend Paul Meme No is in the house, says the best transcript dramatizations in the business. Is that a compliment to us, Paul? Thank you for that. We try to make it, try to liven things up around here. The Blind Lawyer says this is a great ruling from DC. Now judges have no authority to be able to claim that they have any sort of immunity from civil or criminal allegations. Good to see you on Rumble, The Blind Lawyer. Red One. 5 membos got gifted, courtesy of Red One in the house, bringing in Maynor, Carolyn H., Johnny D., Mama Pillows here, along with Philip Hart, courtesy of Red One, who's a membo, bringing in 5 new membos. And thank you for doing that, Red One. New membos. We'll see you tomorrow morning on our membos only stream. Glocky's here. Glocky McGlock says, imagine a bunch of clowns in robes saying you don't have immunity, but they can be pretty much throw innocent people in prison, and make unconstitutional rulings with no fear because they have lifelong immunity. Freedom Forever says there is no conviction. Why is this word used? Good question. Yes, good question. Convicted, right? There was no conviction. It's a good question. Glocky says the judicial system is so corrupt and broke and one-party rule that pretty soon the consequences of all this is going to be more problems. Feds and cops are going to have problems. Yeah, it's going to be spicy. NY says when partisan judges bring about partisan decisions, they always regret it, and the American people suffer. Well, look, precedent swings both ways. It's not good, like they might be happy about what they've done now, but it always backfires. As we speak, Matt Gaetz vows that when Trump is elected to pass a law that would significantly curtail the DOJ and limit the jurisdiction of the D.C. Circuit. It seems like the appeals court ignored Marbury versus Madison. Gaetz wants to remove jurisdiction for presidential executive actions to only SCOTUS. Thank you, NY. Larry says immunity ruling not only opens the door for charges against all other former POTUSes, but also judges congressional actions for crimes that they claim are official acts. Yeah, the thing about it is, I think that they think that they're in control. And they are in control, actually. They control the DOJ, they control the courts, they control many state, offices like secretaries, they control DA offices, Fannie's office, Alvin's office, all of them. It's kind of a nonstop thing. So I don't think that they necessarily care. They're like, well, no one's going to prosecute us. We're not going to prosecute ourselves. So who cares if we just prosecute Trump? Thanks, Larry. Thanks for the nice dono. Alan Cooper is our newest supporter. Jerry Veris is our newest supporter. Welcome aboard, Jerry and Alan. Very nice to see you. Ray says, I would hope that SCOTUS liberal judges can see the writing on the wall if they rule against immunity. Do they want Clinton charged? From Ray Ronk. I don't think, they think, well, we control the DOJ. Who's going to charge Clinton? Who's going to charge him? Some Republicans somewhere? They don't have the nuts to do it, most of them. Chubby says, okay, well, it's time to indict Obama and old Joe now. Those judges are going to set our constitutional republic on fire just because they don't like Trump. Wow. They're doing it. We're watching it burn right in front of our eyes. NY says Biden bombed sites in Yemen. There's no authorization or war declaration. Therefore, Biden can be prosecuted on January 22nd, 2025. Boom. Ordoc says the members of SEAL Team 6 are required by the United States Code of Military Justice to disregard an illegal order and would never kill a person under presidential order. But enemies of the U.S. are allowed to be whacked. OBL, duh, from Ordoc. Ord Rock. Well, apparently Judge Pan didn't know anything about that. And thank you for the dono, Ord Rock. It's a great point, right? It's like, what kind of fantasy land are these people living in where the Navy SEALs are just going to go take out Congress? Weirdos. NY says, Rob, I call the we not at the outset that our analysis is specific to the case before us. Because Trump clause. Oh, the because Trump clause, yeah. And a mantra of the Democratic Party back to when Senator Barbara Boxer. It's not specific facts at hand, but the seriousness of the charge that matters. Basically, not a decision on facts, logic, or law, but on emotion. This is a Democrat leftist way of life. Everything's about emotions and their fifis and how things feel for them and empathy and coexist. They get a bumper sticker, coexist. Yeah, we'll see about that. NY, what's up? Good to see you. We got this one from Dolphin Fan. Is the man bringing in 5 new members? Dolphin Fan is the man. Guess who's coming in? We got Art P. Doctor Who's coming in. G is in the house. Frank B. and Kat Johnson coming in courtesy of Dolphin Fan is the man who's been a member for a very long time and brought in a ton of members. Thank you, Dolphin. Hopefully you're having a great week, my friend. We've got Mini Wheat says, Rob, will Trump's team request en banc on this, or do you think they should go straight to SCOTUS? Can they go straight to SCOTUS, or do they have to request a full panel before they go forward with their appeal? They can go straight to SCOTUS, is my understanding. And, part of their strategy is to delay. And it's a good strategy. It's a common strategy in defense. So I think that they should request en banc. And then if en banc, and actually, if you want to be very aggressive with this, you would actually challenge the ruling that says that they have to submit a brief immediately. Like they changed some of the rules. Why did you change the rules for us? So I would delay, right? I would delay. I'd file en banc when they denied that, then appeal that. And then when they say, well, the application for en banc, when that doesn't stay the lower mandate, I'd appeal that. What's the Supreme Court say? And just delay. We got this one from Pan-Seared Ribeye. Says, if you need en banc before SCOTUS, I could be wrong about that. I'm not sure on that exactly. Pan-Seared Ribeye says, if presidents... Yeah. It says, if president... Do you have to go en banc before you go to SCOTUS? I don't think so. Like, they got denied. You could run it right up. But I don't know that they need to do that. I think I'd rather go the long route, like take the scenic route. Pan-Seared says, if presidents didn't have immunity for official actions taken as president, then every single president would have pardoned themselves before leaving office. This has never been thought necessary. That's another great point. Yeah, why wouldn't they just pardon themselves for everything? That's a good little escape valve, right? If you think that that is the case, and they're going to be, sagged with political prosecutions by Fannie Willis, they'll just pardon themselves. They won't have to litigate that. Hey, Fred is here, says, Judge Pan's appointment Senate hearing on YouTube is horrible. Good to see you, Fred, and your rascally dog, Johnny. We got Red One says, when did the View hosts become judges? Zero logic. Even inconsistent within their own opinion. Crispy Leg Transport says, I hope to see charges brought against 43, 44, and 42. I'm down for it, man. If they're going to charge Trump, go get them all. I'm down with it. We can indict half of Congress for all I care. Good to see you, Crispy Leg. Thanks for the nice dono. We've got, hey, Saint Chef. Oh, my goodness. Saint Chef is bringing in 50 membos in the house. Oh, my goodness. Thank you to Saint Chef, my friends. Saint Chef is bringing in 50 people into our community, and we're going to have member-only streams in the morning, Saturday streams, and other great stuff. Angelia G, Pan-Seared Ribeye, Vermont Red Pill, B Crouch, Ted B, Brad T, Raul R, Lowell S, Saffon is here, Greg E, we got Misfit News, Magoose is coming in the house. Who else is here? William L, welcome aboard to Eric L, Silent Rage, James H, Tyrannius Cygnus is here, Philip H, Kathy R, Angry Viking Veteran is joining us, Deborah M, W Daisy Girl, we got Damon W, Toenail H, and another one from this person called HD is coming in the house. Stephen E, Jill C, Drive for Your Life is here, Nana's coming in, Sheila P, Audie Joe, Ramon F, Justin Y, Sup Forrest G, Mike H is here, Chris Culp is in the house, along with Anthony, Dustin the Wind, Matthew S, Thos L, that guy, James F, April A, May M, Jackson Schofield, and Piper L, along with Snoop, Carrie, Chuck, and George, all coming in courtesy of our very generous friend, Saint Chef, in the house. 50 new membos. Oh my goodness. Well, welcome aboard. We've got this one. Saint Chef saying, enjoy everyone. A membo for 11 months. Amazing, Saint Chef. Thanks for doing that. Almost a full anniversary, my friend, on the year. Thanks for being here and for saying that. And for being here. Really grateful for you, Saint Chef. Thanks a bunch. 11 months as a membo and 50 new membos. Wow. Very cool. Okay. Jeffrey Adams says, Rob, this is what you get. This is what you get with the DEI appointments. Hey man, I don't, that's the kind of judicial opinions that we're getting out there now. We got Glocky's in the house. Says, Rob, what do you think Smith will do? Do you think Trump's lawyer called his bluff on this? Good question. This old guy says, if I were a DC appellate judge who was not on this panel, I'd be thanking my lucky stars that I didn't have to sign my name to it. Yes, well, because it wouldn't wreck your career. Hey, Glocky, we're going to come back. We'll see if we can get to that one on the after party. We got this one from BJS says, does this mean we can now prosecute judges absent impeachment? Well, they, as you saw, they very narrowly crafted this. So it only applies to Trump only. And everything else is kind of status quo. But good to see you, BJS. We got Neurodivergent says, Rob, question. So Trump wins in November. He gives you the choice of AG or appointment to the Supreme Court. Which would you choose? SCOTUS. Yeah, definitely SCOTUS. I'm 38, man. I could do a lot of good on SCOTUS for the next 50 years. Let's go. Definitely. Hey, what's up, Neuro? Glocky says, no, Rob needs to be White House counsel. Well, that's another one, too. Look, I'll take what I can get, okay? If he's like AG, if he's like, Rob, look, we don't have a SCOTUS appointment for you. Would you take AG? I'll be like, I mean, I guess if I have to, I guess so. Who's going on SCOTUS? Who are you putting on SCOTUS? Viva? Fine. Okay, put Viva on SCOTUS. I'll take AG. NY's here says, all right, almost every expert expected things to go this way. DC Appellate Court is swamp Grand Central. I can't wait for Trump's appointment to that circuit. And I'm sure someone is penning Biden's indictment waiting for Jan 22 to be brought in a friendly circuit like Texas, Alabama, Florida, or the border invasion. Yeah, I'll be the pool guy for the White House too. Whatever, man. I'll skim the pool. I'll clean out the skimmers. All right. Whatever. I'll do it. We got NY. We got Glocky. Whatever I'm needed to do, man. I'm trying to save this country. If I got to go skim the pool, that's fine. Glocky says, okay, Rob, con law question. Republicans are projected to sweep the Senate but lose the House, and Trump is so far on track to win the executive. Can they then break up the court districts, shut down the DC district, and fire the judges? Yeah, I think Congress can set the jurisdiction of the courts. So yeah, I think they could. This one from Glocky. And NY says, the Supremes can decide that Smith is an imposter sua sponte. Trump can make the argument at any time, even right up after this appeal. Why speed it up for Smith? That's a good point. Pinecone, bringing in new membos. What's up, Pinecone? Thanks for being a membo and bringing in our newest membo, G. Rick. NY says, so this is the way it needs to happen, folks. Dems are doing a happy dance. Hope they keep good old Joe in. Their hubris will be their undoing. And I think that their hubris is like, it's the dog that caught the car. What are you going to do with it now? You got your indictments and your trials. Let's go. Spidey says, is Abba a bad lawyer like Midas Touch says daily? No, I don't think so at all. Midas Touch, that lefty channel on YouTube, right? Where they just talk about Trump all day, 24/7. Of course they would say that. Rob says, isn't the president is elected to be the executive branch? He's not elected to be in office within the executive branch. Yeah, he is zero. Like, he is the root power. A special prosecutor must be appointed to an office created by Congress, or as like Edmise said, at least appointed and confirmed by the Senate. Thank you for that, Rob. Aussie says, did Pelosi and Pence work together on January 6th? I don't know. They seemed pretty chummy on those phone calls. Rocky says, Rob, I love the argument about the previous draft of the Constitution being changed specifically to remove the word president. Hadn't known that before. To me, it's a clear showstopper, but we'll see. Anyhow, thanks as always. Great info. Appreciate what you do and how you do it, brother. Well, thank you, Rocky. Rocky, I appreciate you, man. And what I like about Rocky is his tips are always kind of, random numbers. Not a lot of rhyme or reason to them. Keeping us guessing. Thank you, Rocky. I appreciate it. I agree. We've seen that come up here before, but not as I think concretely as that. Like he said, the representative introduced it and removed it. So I thought that research was very good. Hey, breaking news. Impeachment against Mayorkas fails because 4 Republicans are cowards. That's true. And that's what we suspect. So like what happens if those people still vote with the Democrats and against Matt Gaetz on the impeachment resolution, right? Hey, Black's Law Dictionary has a clear definition of insurrection, doesn't it? I'm surprised I don't see that reference anymore. I thought Black's was the go-to for such disputes on definitions. Black's Law Dictionary, very common dictionary that lawyers use. Rob says Chuck Schumer was expelled from and failed pre-kindergarten with Pelosi and these partisan Democrat judges. Crash is writing, saying New York wrote, Dems are victims of their own ravenous political beast. The First Circuit will hear this en banc because these judges cannot wait to get their time in the sun on this case. I agree, wholly agree. All the time in the sun, well, SCOTUS will rain on them. NY says, I'm not sure if the House votes and the Senate does not, if it means anything. Joanne says, Mayorkas was not impeached 5 rhinos are destroying the United States. A membo for 3 months. Thank you, Joanne. We got Kelly says, our government is smoke and mirrors, just pulling our strings. I fear that's the truth. I think that's accurate, actually. I don't think that they're really working for us at all anymore. At all. They're not even faking it, as this border bill showed us. Knox says, happy Tuesday, all. One of the bailiffs told me about the arrest of this rapper who, prior to the award ceremony, would not endorse Biden and apparently leaned towards supporting Trump. And that was Killer Mike. He got arrested, probably taken out to the gulags by the Bidens. Neuro says, wasn't there some discussion when the Republican won the House about voting to nullify the impeachment? Maybe. I don't recall. Yeah, maybe. They talked about also forming their own J6 committee and a bunch of other stuff. This one came in from Don Schuler. The House just voted to and failed to vote in Mayorkas. From Don Schuler. The House just voted, failed to impeach Mayorkas. Thank you, Don. Lemon says, later, my friends, see you on the next one over on Rumble. Good to see you, Lemon Zinger. Rob says, wouldn't just expunging the impeachment be the same statement, do the same thing, make it go away? There is no response required from the Senate. BH says, allegedly, Blake Moore voted nay, so it could be brought up again. You just have to vote within the majority to ask for reconsideration. They want to twist arms and then come back when Scalise says to try again when he comes back. Joe Mass says, when do we indict Obama for killing Americans overseas without due process? Ex-presidents aren't immune, you know. We just learned that. And NY says, Turley says the en banc will delay at least 2 months, which I think is true. But the problem with that is that Chutkan would put the trial back on the schedule. So we got to clarify that issue as well. My friends, thank you for those very generous donos. We went through them quickly because we're a little short on time today, but thank you for sending them in. I'm very grateful for them. We've got a bunch of new membos, new YouTube membos. Make sure you grab the Telegram link if you want to join us for the members only after party. It's down in the community tab section. Scroll on down and grab it there. We got a couple comments on the X platform, and Paul Minot, our meme smith, says it's always in the eyes. It's always in the eyes. Crazy eyes, Jena. And that girl, that overly obsessed girlfriend. Very good one from Paul Minot. Very nice to have you back. Breaking news from Paul. We've got Fannie Willis taint investigators are retrieving evidence. Another good one from Paul. Hey, Barb's is here, failing to impeach. Vientika says, I like how people keep calling some rhinos, but no one says linos or dinos. James Pepper's in the house. Danny McWilliams is in the house. Bunch of Dark Side's in the house. What's up? Danny says, reject presidential immunity. Do they have any idea where that will lead? Dark Side says, someone should remind those DC judges it's to vindicate the public's interest, not the Democrats' interest. And so, very good to see you. Goofy for Jesus, Peter, K, Buff, Chetty, what's up? Jay Howard's in the house. Very good to see you, my friends, over on the X platform. You can follow us at Rob Govea ESQ if you want to follow us there. But that, my friends, is it for us on the day. We're going to have a very short after party at watchingthewatchers.locals.com. Come and join us over there. We also have our website, robertgovea.com, to grab the PDFs, the show reports. The shop is there. And of course, all of our events are at watcherlodge.com. We got a great one coming up tomorrow. We'd love to see you. It will be live and active for 48 hours. Then it's going behind the archive. So come and join us, watcherlodge.com, to participate in that. We want to thank our mods and our meme smiths, our friends Vientikas Prime. We got K Bean in the house, Just Cause, Playin' Hooky, Ronnie Cole, our friend Zulu, Beyond Geo, Zach Nichols is here, John Allen, Janik 909, Dog Digger, and Donut Mind Me clipping away for us, modding the fort down every day. Sleepy Dog Lee, Jeegum Geegum, and Nathan N810 all in the house, my friends. That is it for us on the day. We are going over to watchingthewatchers.locals.com for our very short after party. Come and check us out if you want to join up. We'll be back in the morning there on Locals and on YouTube for our members only morning stream. But that is it for us on the day here today, my friends. We are going to leave it up right there. And we are going to be back here tomorrow. And we need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.